257 votes to impeach in the House of Representatives, 21 senators sitting in impeachment court, 4 articles of impeachment, and 1 impeachable official. The impeachment trial of Vice President Sara Duterte begins today, and Rappler will be with you every step of the way. Hi, I'm John Nery, and you are watching Rappler's special coverage of the Duterte impeachment trial. Joining me in the newsroom is constitutional law expert and University of the Philippines law professor, Attorney John Molo. And reporting from the Senate are multimedia reporters Dwight De Leon, Jairo Boliedo, and Patrick Cruz, giving us first-hand coverage of the trial. Rappler's Iya Gozum is also reporting from the field, covering the protest outside the Senate. You can interact with our reporters and desk editors throughout our coverage by downloading the Rappler app and joining the impeachment trial chat room. The trial begins at 2 p.m. today, July the 6th. And we know that Vice President Sara Duterte is not appearing in person, as her spokesperson, Michael Poa, told us just a few minutes ago.
Gaano kahalaga itong impeachment trial para sa future ni Vice President Sara Duterte?
Jairo, Patrick, this impeachment trial will be the ultimate test of the popularity of Vice President Sara Duterte. Susukatin ng paglilitis na ito yung lalim ng suporta ng mga Pilipinong hanggang ngayon ay naniniwalang inosente si Vice President Sara sa kabila ng napakaraming mga aligasyong ibinato sa kanya. Over the weekend, I reviewed the survey numbers for VP Sara. Kung tingnan mo ang numbers from SWS, ang net satisfaction ni Vice President Sara ay positive 26. It's comparatively lower kung ikukumpara mo sa mga nagdaang vice-presidente but significantly higher than President Ferdinand Marcos Jr. na nasa negative 15 ang net satisfaction as of the first quarter of 2026. Ibig sabihin, si Vice President Sara pa rin ang pinagkakatiwalaang opisyales ng ating pamahalaan. But Vice President Sara is unlike her father when it comes to popularity. Nang umupo si Rodrigo Duterte bilang Pangulo in 2016, ang kanyang net satisfaction ay nasa positive 64. And in 2022, noong natapos ang kanyang 6 na taong termino sa kabila ng napakaraming kontrobersiya, kabilang ang bloody war on drugs, ang net satisfaction ng dating Pangulo ay umakyat pa to positive 81. So Vice President Sara Duterte is the candidate to beat in the 2028 elections because she has declared her presidential ambitions, but that doesn't necessarily mean that she is unbeatable. May survey ang Pulse Asia indicating na may laban si former Vice President Leni Robredo or si Senator Raffy Tulfo in hypothetical two-way matchups against the Vice President. Why am I saying this? Because the trial is such a high-stakes affair. A conviction for the Vice President will result in her immediate disqualification from public office. Yes, Vice President Sara may resign before the trial starts, during the trial proper, but there is a school of thought na kahit paggawin niya ito, the trial should proceed para malaman kung i-impose ba ang penalty of perpetual disqualification. The trial will put all her dirty laundry out in the open. So it is a challenge. It is a challenge for the prosecution to articulate fully their case, to ensure that evidence is tight, and to ensure that allegations are easily understood by the public. It is also a challenge for the defense team, for the camp of Vice President Sara Duterte, to finally face the music and stop resorting to blanket denials, something that she did in the past 2 years every time may binabatong alegasyon sa kanya. It is a challenge for the Senate impeachment court to make sure that they are fair and that they are devoid of partiality and ensure that the impeachment trial, the impeachment process, is a mechanism designed by the 1987 Constitution to ensure that our highest officials are held to account. And it is a challenge for the Filipino people to follow this trial with an open mind and monitor this process every step of the way.
Gaano kahalaga itong impeachment?
Thank you. That was Dwight De Leon earlier today reporting from the Senate on what is at stake for Vice President Sara Duterte? Attorney John, I want to expand that discussion. What else is at stake in this trial?
Well, quite a lot. Well, nominally, of course, it's about 2028. The elections are at stake. But we shouldn't forget that this is also about the Constitution. And impeachment is about accountability. So what's really at stake for me, as a professor also, is that there's the moral fabric of the nation as well. It's actually a test of our institutions.
Okay.
And it's also a test of our leaders. And ultimately a test of the public. Because as the trial goes, we will see finally whether or not the prosecution has something to present to prove their allegations. Because all of these are really just allegations at this point.
Yes.
Now's the time that we finally get to see what's there. It becomes a test because once malatag yan lahat, doon natin makikita, talaga bang partisan tayo, yung leaders natin, or are we really willing to let the process play out?
Let me ask you, regarding 2028, no, to go back to the first point that you raised, in what way could this trial help Sara Duterte regarding her prospects for 2028? And in what way will it hurt her?
Well, the legal effect of an impeachment, especially if it's bad for her, is automatically perpetual disqualification. So, but going beyond that, it could actually help her, however, if she gets an acquittal or she is not convicted in this trial, because it's actually a validation of everything she said over the past almost more than 1 year since this saga started. It's a validation of their platform. It's a validation of their causes, their advocacy, and it will also bolster the belief of her supporters and her allies.
Let's talk about the Senate that is now that will in a few minutes sit as the impeachment court. No? There have been many developments. May 11, there was the Senate coup. On the very same day that the House of Representatives impeached for the second time the Vice President. 2 senators are now in detention, and of course there's a third one who is in hiding. We can't help but also think about the Senate itself. No, is it even functional? Will it function well as an impeachment court?
Yeah, kaya nga dun sa first question mo pa lang, John, parang ang sagot ko kagad, it's a test of institution.
Okay.
Because at the core of this trial is the institution of the Senate itself, right? So, the Senate was designed precisely to be a nationally elected body, not that the district level representatives like the Batasan or the House of Representatives. So ang ini-envision ng framers natin dyan, medyo mas malawakan, mas wide ang scope ng pinag-iisipan ng mga umuupo dyan kasi they think of the entire country, not just their bailiwick.
Alright.
In an impeachment court, that's gonna be tested. Ano ba talaga? Gaano ba kalawak ang iyong concern para sa bansa o talagang para lang sa short term or para sa bailiwick or sa baluarte mo or para sa kakampi mo? So, it's a real test of the Senate. And we've seen that before. I think in 2001, the Senate was tested and it was just a very small vote whether or not to open one small envelope. I'd like to think that they failed that test because precisely nagalit yung taong bayan. So,
this is the Jose Velarde.
The Jose Velarde
account. Impeachment trial.
Yes, and hopefully we do not, our senators have learned from history and we do not encounter a similar situation. It's 2026, 25 years later. Hopefully we've learned our lesson from that.
Here's a report from our Patrick Cruz about the Senate's divisions and how these could affect the trial, including the Marcoleta factor. He surrendered today after the arrest warrant was issued, and maybe also a discussion about the conviction threshold.
Okay.
Here in the Senate, saka yung kung paano nangyayari itong impeachment trial na to dahil it unfolds under a highly divided Senate. There's the Gatchalian bloc and there's also the Cayetano bloc. So yung Gatchalian bloc ngayon, yung ruling dito sa Senado. In the past, we saw na how divided they are. Yung Cayetano bloc, alam naman natin yung affiliation nila. Many of them are in one way or another linked or has strong ties with the Duterte family. And many of them, in the previous impeachment trial, at least dun sa first one na in archive, push for the dismissal of the impeachment complaint against the Vice President Sara Duterte. And also interesting nga rin kasi yung in terms of the numbers, 13 members ngayon yung majority block ng Cayetano or the Gatchalian block, and then 11 naman yung nasa under the Cayetano faction. And at least dun sa 11 na yon, si Senator Bato de la Rosa nagtatago ngayon because of an ICC warrant of arrest. Si Senator Jinggoy Estrada naman hindi rin maka-attend because also in jail because of a plunder case. And now, si Senator Rodante Marcoleta is facing a plunder case, and yung Sandigan Bayan earlier today nag-issue rin ng warrant of arrest. So, it's interesting if Senator Marcoleta would make it today in this impeachment trial. And also, in terms of the numbers, kasi quite contentious kung paano magpe-play out itong impeachment trial na to, kung paano mako-convict si Sara Duterte. Because under the rules, di ba dapat 2/3 at least
Constitution, yes.
Constitution.
ng mga senator dapat yung mag-rule or mag-decide na ma-convict si Vice President Sara Duterte. But given these numbers, mag-a-adjust ba yung Senate kung alin ba yung ipa-follow nila? Kasi if 24 yung members ng Senado, dapat merong at least 16
Yes.
members yung mag-convict sa kanya. Pero with now, considering na wala si Senator Bato de la Rosa, Senator Jinggoy Estrada, and possible arrest of Senator Marcoleta, that brings down the number of senators who can physically attend here in the Senate to at least 21. And yung 2/3 na yon ay 14. So, ang question ngayon sa impeachment court ay, ano yung ifa-follow nila na 2/3? Is it the 16 or is it the 14? So, and also interesting din na kung sino ba yung magpe-preside dito sa impeachment trial ni Vice President Sara Duterte. Under the rules, it's the Senate President, so that's Senator Win Gatchalian. Pero meron ding inapprove na amendment dun sa rules ng Senate allowing a senator other than the Senate President to preside over the impeachment trial. And yung isa sa mga names na flinote ay si Senator Chis Escudero, who previously also presided over the trial ni Vice President Sara Duterte. And at that time, yung leadership niya was criticized kasi siya yung under his leadership in archive.
Sa remand.
Sa remand yung impeachment complaint against Vice President Sara Duterte. So merong opposition for him to take over yung role ng pagiging presiding officer. Although at some point, meron din naman na nagsasabi na okay na maging presiding officer si Chis Escudero because of his legal background, is a lawyer. So, and as you mentioned, yung impeachment court is quasi-political, quasi-legal. So, it requires legal knowledge and at least have a sense of idea or knowledge about the rules of court and kung paano ba tumatakbo ang isang korte. So, that will be decided later, if ever. But still, they have to secure yung majority vote para mag-elect ng bagong presiding officer. So, yeah, as mentioned, yung trial nga, Jairo, paano naman yung mangyayari sa trial later? Ano yung inaasahan natin magiging flow? It's interesting here in the...
Thank you. It is interesting. I'd like to throw back to you those two questions. No? So first, yung conviction threshold na 2/3. Ano? So if there are 2 senators in detention, 1 in hiding, what should be the number of votes from the impeachment court needed to convict Vice President Sara Duterte? Maybe we can start with that one.
Yeah, well, of course, there's a debate right now.
Yeah.
But starting with what the Constitution actually says, it says 2/3
Okay.
of all the members of the Senate. Now, a lot of people are now parsing what 2/3 of all the members of the Senate means. Kasi
Okay.
I think lahat naman tayo mag-agree kung ano yung sabihin ng 2/3. Lahat tayo nag-agree
I hope
kung
so.
Senate and all. I think the real dispute is who would count as a member of the Senate
Okay.
when that vote arrives.
Right.
All right. So, of course, both sides have cited their own precedents. But ang medyo kaya nagiging issue din to is because if we can recall, couple of weeks back, more than a couple of weeks actually, parang naging sobrang sikat yung kaso ng Avellino versus Cuenco.
That's right.
And if susundan mo kasi yung series ng mga kaso na yon, that same case was not directly upheld but was kept on being used as a reference by the Supreme Court in several succeeding cases. Doon biglang nabuksan yung possibility na yung members of the Senate for purposes of computing any threshold, hindi lang yung 2/3, maraming threshold sa Constitution, maaaring magbago. Kasi kung babalikan mo yung Avellino versus Cuenco, open pala yung Supreme Court na pag nasa US yung isang senador, hindi mo siya kailangang bilangin for purposes of quorum. So since inulit-ulit nila yung ganong klaseng logic in subsequent cases, it became sa side naman ng mga taong nagsabi na, maybe the effective threshold should not be based on all members of the Senate as a fixed number, 24. Doon nagkaroon ng gap. Kasi nga, we have never encountered a situation like this before. I think there was one time na may senador, I think it was Senator Gingona, was appointed as Vice President. So, nagbago yung number na yon. But to actually see the Marcoleta, they say, was arrested today, Jinggoy, and another one, and then I think we have now 4. It could be more pa during the trial. Honestly, it might come to a point that if you follow the rigid thinking na it's really just 2/3 of 24, then the trial might be moot and we might as well not hold the trial.
But if the senators decide to change the voting threshold, okay, so our 2/3 now is 14 or whatever, right? What kind of vote do they need? Is it just simple majority vote, or do they also among themselves need to reach a 2/3?
It still has
Threshold.
to be a 2/3. 2/3 is fixed in the Constitution. What they will now
No,
have
to change the
to
threshold.
change.
To change the
Oh,
threshold.
You can't change the 2/3 that part. But who counts as a member for purposes of computing the 2/3
Okay.
at any given point?
Yeah.
Maybe that's what they need to discuss.
Yeah, so that vote, like who is a member? We define a member as someone
Yeah.
who was in the trial and can
Yeah.
actually appraise the evidence and so on. You just need a simple majority of senators,
Yeah.
right?
If we're gonna be tautological about it, we go by the Senate rules, and under the
Okay.
Senate rules to change it, then you will, once you have a quorum, you just have a simple majority to change the rules,
Okay.
which is exactly how they changed the rules when they allowed another senator other than the Senate President. So ganun din nila ginawa yun.
But is that what we're looking at today? Will it be Jesus Cadero, not Senate President Win Gatchalian?
I think it's gonna be Senator Gatchalian, the Senate President himself, because I think I've seen some
That's right.
quotes that he said he's gonna be the presiding officer today.
That's right. I remember interviewing the retired Justice Adolfo Ascuna, who said, you don't need to be a lawyer to preside.
Oh, yeah.
Even though it's a quasi-judicial process. I have a question about the nature of the impeachment trial as an act of political justice. All right. So nabanggit kanina ni Patrick na how deeply polarized the Senate is. Right? So you might have some senators who, whatever the evidence is, will never change their mind. They've already made up their mind. Maybe it's possible, right? But you also have someone like, the late, great Father Joaquin Bernas saying, well, in the end, it's a numbers game. It's an act of political justice. How do you weigh these two opposites?
Well, first of all, again, we go back to the concept of a Senate. Ideal kasi ng Senado is that it's made up of statesmen, stateswomen, right, who can think of the greater things in life and for the country. Okay. But again, the real politic is that people who get elected to the Senate rely on political networks and connections, and of course, money and power. So, but the reality is also the Constitution, those who framed it, also knows that. So when people say that, John, yung alam mo naman na this senator will never vote against this senator, isn't that bad? So ang sagot ko doon, that's not bad. That's by design. Because the constitutional framers could have placed it in the Supreme Court, but they chose to place it in a political institution. So for me, it is also the reason why I say this is also a test on the public. Not just on the leaders, but on the public. Why? Because since these are politicians we're talking about who are going to preside, then the only way to pressure a politician is by the public utilizing their voice.
Okay.
Because that's the only thing that politicians listen to. So for me, merong role na gaganapin ng public sa trial na to. Every citizen will have to participate at one level or another because that's the way that it was designed. It was not designed to be like a secret decision in a conference room. Now it's televised, the entire nation is watching precisely because that's factored in. Ganun ko siya hihimayin.
Now that Senate President Win Gatchalian will serve as the presiding officer, even though Chis Escudero is with the majority now, I would like to ask you how you think Win Gatchalian will handle this differently from the way Chis Escudero handled it last year during the first impeachment trial.
You know, I will take the contrarian view, and I think Senate President Gatchalian will be a good choice to preside over any other lawyer in the Senate right now.
Okay.
Because right now, ang sentimiento ng public, we've seen how a lawyer, like say, Senator Chis Escudero handled last year's trial. And there was a very strong backlash against it because of all of the legalities. Now, make no mistake, lahat naman ng sinabi ni Senator Chis at that time had legal basis.
Sure.
He was citing rules. But I think right now, the public, even the Vice President's own supporters, are tired of the rules and technicalities getting in the way of the trial, getting in the way of the truth. So having a non-lawyer as your presiding officer is actually a good thing because, you know, not a lot of people actually know that there is arbitration as part of our system. Okay? Hindi lang korte, may arbitration tayo tinatawag. Sa arbitration, maraming arbitrator, hindi naman abogado. And some of the best arbitrators I know, for example, in construction arbitration, are not lawyers. Some of them are scientists, some of them are engineers, okay? But so you cannot say na porket hindi abogado, hindi kaya mag-preside. Yung iba dyan, ang gagaling, hindi naman abogado. Kasi ang batas, yung procedure, naaaral, and then each senator has an entire support staff of lawyers who can guide them. So at this point, the concern is transparency, truth, what really happened. Having a non-lawyer preside over the trial might actually be good.
Just a quick note to our viewers, as we get closer to 2 p.m., you can send your insights and comments throughout the coverage at the impeachment trial chat room in the Rappler app. Attorney John, what are your personal expectations today? I mean, are we looking forward to the opening statements, or is there a surprise you think that might?
Sa akin, for me, since you said expectation, I really hope there are opening statements. Because until 25 years later, until today, naalala ko pa rin yung opening statements nung impeachment ni Erap. Right? And I still remember yung catchphrase na ginamit ni the late Senator Joker Arroyo when he said that our country cannot be presided by a thief.
Okay.
Right? So I'm looking forward to opening statements because it precisely sets the tone of what each side is going to do. The prosecution should have a strong one, and the defense should have a strong one. I'm also looking forward to how the presiding officer will set the tone of the trial. Is it going to be a contentious, legalities-based approach? Or is it going to be an exercise where the concern of the court is to find out the truth? And maybe, hopefully, although ngayon meron na tayong response na hindi siya dadating, hindi siya attend, I'm looking forward to that point that where even if she doesn't testify,
all persons
she
are
attends.
commanded to keep silent under pain of penalty while the impeachment court is in session for the trial of Vice
The
President
Sergeant at
Sara
Arms is
Zimmerman
directed to make a
Duterte.
proclamation. The impeachment trial of Vice President Sara Zimmerman Duterte is hereby called to
All
order.
persons are commanded to keep silent under pain of penalty while the impeachment court is in session for the trial of Vice President Sara Zimmerman Duterte.
We shall be led in prayer by Senator Bam Aquino. The impeachment trial of Vice President Sara Zimmerman Duterte is hereby called to order.
Panginoong
We
Diyos,
shall be led in prayer by Senator Bam Aquino.
lumalapit po kami sa inyo upang gabayan niyo po kami sa aming tungkulin. Pagkalooban niyo po kami ng malinaw na pag-iisip, Panginoong Diyos, upang hanapin at makita ang katotohanan po kami sa inyo na walang kinikilingan. Upang gabayan niyo po kami Panginoon, sa aming tungkulin. Ipaalala niyo po sa amin ang aming kapangyarihang pinagkatiwala hanapin at makita ay hindi dapat gamitin na wala sa sarili kung hindi para lang sa bayan. Panginoon, naway ang prosesong ito ay maging daan upang mapagtibay ang katarungan at tiwala ng mamamayan. Ay hindi dapat gamitin sa gitna ng prosesong ito para lang sa bayan. Sa kabila ng mga magkakaibang pananaw at paninindigan upang mapagtibay dalangin namin na magkaisa kaming lahat alang-alang sa katotohanan at katarungan. Sa gitna ng prosesong ito, pagkalooban niyo po kami ng lakas ng loob pananaw at paninindigan na ipaglaban ng tama, dalangin namin ng karunungang kumilala sa katotohanan alang-alang sa katotohanan at ng pusong laging inuuna ang kapakanan ng inang bayan. Ng lakas ng loob. Ito po ang aming taimtim na panalangin. At ng pusong laging inuuna ang kapakanan ng inang bayan.
Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the Senate President.
With 21 senators present, the chair declares the presence of a quorum. The court was convened on May 18, 2026. For the record, since then, the court has issued summons and conducted pre-trial proceedings, which are all made part of the records of this case. Resolution number 39, or the Rules of Procedure of Impeachment Trials, as amended, shall continue to apply.
Your Honors, we are now ready to hear the statement of the Senate President.
Before we begin, with the court's kind indulgence, I wish to deliver a brief opening statement. Ladies and gentlemen, distinguished senator judges, sa araw na ito, binubuksan natin ang pagdinig sa kasong impeachment laban sa pangalawang Pangulo ng Republika ng Pilipinas, ang kagalang-galang na Sara Zimmerman Duterte, alinsunod sa ating saligang batas. Sa pagtupad natin sa tungkuling ito, malinaw ang panata na ating sinumpaan to do impartial justice according to the Constitution and the laws of the Philippines. Ibig sabihin nito, ang bawat pasya natin ay dapat nakabatay lamang sa saligang batas, sa ating mga batas, sa mga alintuntunin ng hukumang ito, at sa mga ebidensyang ihaharap na walang kinikilingan at walang pinapanigan. Impeachment is a constitutional mechanism that holds the highest public officials of the Republic accountable to the people. We cannot achieve accountability, nor can we faithfully serve justice without the truth. Karapatan ng sambayanan na malaman kung may katotohanan ang mga paratang laban sa pangalawang Pangulo. Tungkulin nating timbangin ang mga ebidensyang ihaharap at tiyakin ang ating magiging pasya ay nakabatay lamang sa batas at sa mga katotohanang mapatutunayan sa paglilitis. Ipagkakaloob ng saligang batas sa Senado ang natatanging kapangyarihang dinggin, litisin at pagpasyan ang lahat ng kaso ng impeachment. Kakibat ito ang pananugutang tiyakin na ang paglilitis ay isinasagawa ng may integridad, kaayusan at buong paggalang sa proseso. Sisiguraduhin natin na magiging maayos, bukas at madaling maunawaan ng ating mga kababayan ang prosesong ito. Pagkakaloban ang magkabilang panig, ang prosekusyon at ang depensa ng sapat at makatarungang pagkakataon upang magharap ng ebidensya, magsuri at magtanong sa mga testigo at mailahad ng buo ang kani-kanilang mga argumento. Sa ganitong paraan, mahiharap sa taong bayan ang malinaw na batayan upang maunawaan ang mga isyong nakapaloob sa Articles of Impeachment. Kasabay ng paghahanap sa katotohanan, ang tungkulin natin tiyakin, iginagalang ang mga karapatan ng bawat panig, lalo na ang karapatan ng respondent Vice President sa isang patas at makatarungan paglilitis. Due process and fair play must remain paramount at every stage of this trial. Let us be firm in the search for truth. Let us remain faithful to the rules of this court, the rule of law, and above all, the Constitution. Nakatutok ang buong sambayanan. Bawat kilos, salita, at pagpapasyang ating gagawin ay huhubog sa kasaysayan. At ang kasaysayan ang huling huhusga kung tayo ay kumilos ng tapat at nararapat. Nais kong bigyan ng katiyakan ng lahat, lalo na ang ating mga kababayan. Gagampanan ko ang aking tungkulin ng patas at may katapatan. Magalang kong hinihikayat ang bawat senator judge naway tuparin natin ang ating tungkulin ng may dangal at pananugatan sa ating konstitusyon upang maging karapat-dapat tayo sa tiwalang ipinagkaloob sa atin ng sambayanang Pilipino. Thank you, distinguished Senator Judges. Pursuant to Rule 2, Paragraph 2 of the Rules of Procedure on Impeachment Trials, as amended, we now proceed to the election of the presiding officer of the impeachment court. Senator Judge Panfilo Lacson is recognized for the election.
Point of order, Mr. Presiding Officer.
Yes, we recognize the gentleman from Taguig.
Thank you, Mr. President. Mr. President, Mr. Senate President and Presiding Officer, as the preamble of the Constitution said, imploring the aid of the Almighty God, and as you said yourself, that every stage of this impeachment, we have to make sure na patas, we have to make sure na may due process, we have to make sure that it is fair. It is very clear in the Constitution of the Philippines that the presiding officer is the Senate President. Section 3, Paragraph 6 of Article 11 of the 1987 Constitution, the Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senator shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. I will go to that other 2/3 inquiry later on because this is another threshold issue, Mr. President. But to further the point of order with the indulgence of Senator Lacson so that we can discuss this intelligently. On the final question of whether impeachment, on the issue of who shall preside, under the Constitution, it may seem that it does not say who should preside. But if you look at the records of the Constitutional Commission, number 40, 26 July 1986, the framers deliberately chose the phrase, sorry, Mr. President. I am referring to Section 6, Article 11, and then Constitutional Commission number 41, 27 July 1986. The presiding officer, Mr. Treñas, Commissioner Davide is recognized. Thank you, Mr. Presiding Officer. I have some proposed amendments on Section 3, subparagraph 5. The presiding officer, Mr. Treñas, the gentleman may proceed. Mr. Davide, who later became Chief Justice, this is without prejudice to whatever amendments may be accepted by the committee when the Aquino amendments will be taken up. It would consist in adding a new sentence on line 20 before the phrase "no person shall be convicted," inserted the following: all other cases, the President of the Senate shall preside. The presiding officer, what does the committee say? Mr. Munsod, is it not understood that when the President of the Philippines is on trial, it is only time when the Chief Justice of the Supreme Court will preside? It is necessary to say that the Senate President shall decide during all the time. Presiding Officer, Mr. Davide, Mr. Presiding Officer, I precisely presented this because we had a distinction when it comes to the Chief Justice Supreme Court. But with that clarification, that in all other cases, it should be the President of the Senate who shall preside, I withdraw my amendment. So it is but elementary, Mr. President, in statutory, especially construction of the Constitution, that the spirit as well as the letter is followed. The spirit of the Constitution is that it is the Senate President who will preside. This is not an ordinary statement, dictum, or it was not a capricious statement in the discussion, precisely because the Senate President is elected by the majority. As an example, when Senator Pimentel did not like the vote and did not vote with the majority, he offered to resign. So the point, Mr. President, is this. Number one, institutional integrity. We need to protect the legitimacy of these proceedings. Even with the substitute presiding officer acts fairly, a conviction or acquittal reached under constitutionally defective process would invite judicial challenge and cast doubt on the validity of the entire trial. Do we want to go 30 weeks? If we follow the number of days submitted in the pre-trial, 62 and 30, and 3 days every week, so 30 weeks yon. Then after the 30 weeks, we'll end up in the Supreme Court kasi kune-question natin kung tama ba kung sinong nag-preside. Why is it important? Why can't any of the 24 preside? Remember, under our very rules, hindi ko nababasahin para mas umikli. In our very rules, the presiding officer can decide on the spot, or he can throw it to the body, or he can call a caucus or whatever you call it to be able to decide. And we experienced that during the Corona trial, and that's one reason why everyone acclaimed the late Senate President Enrile, not only because of how he carried it himself, but how the consensus and how he carried it with the minority. Secondly, jurisdiction and regularity. The Senate's jurisdiction over an impeachment trial is constitutional. The exercise of jurisdiction must conform to the Constitution, and the Senate's validity adopted impeachment rules. We cannot say we're following the Constitution, then we will not follow the Constitution. If the Constitution and its framers prescribe who shall preside, who are we to change the Constitution here today? We cannot enlarge or diminish the Constitution arrangement through internal rules or through ad hoc resolution. Lastly, due process. Kailangan malinaw po sa lahat ng partido, both to the prosecution and the defense, kung ano yung korte, kung ano ang two-thirds, kung ano ang charges, kung sino magpre-preside. So kung now, during the first day, we're going to change who's going to preside, and it's against the Constitution, what more changes are we going to do in the next few days? Ano ang limit ng pwede natin palitan sa Constitution at hindi? The authority must come from the Constitution or the governing law, not from the vote of a tribunal. A litigant is entitled to have the case heard by the decision maker, designation by law. The law cannot say that ang mag-hear kay Senator Marcoleta ay Sandigan Bayan, tapos sa Court of Appeals natin siya dadalhin. Hindi pwedeng sabihin sa RTC dapat i-hearing si Juan de la Cruz, tapos sa Sandigan Bayan natin dadalhin. Hindi pwedeng sabihin tatlo sila sa CA, pero in this case, nagbotohan kami, isa lang kaming mag-hearing. Proceedings before a judge or hearing officer who lacks the legal authority are invalid regardless of fairness of the proceedings. A judgment rendered by court without jurisdiction is null and void and may be attacked anytime. It creates no right and produces no effect. It remains basic fact that in law, the choice of the proper forum is crucial, as the decision of a court or tribunal without jurisdiction is a total nullity. A void judgment for want of jurisdiction is no judgment at all. All performed pursuant to it and claims emanating from it have no legal effect. Tan versus Cinco, GR number 213054, June 15, 2016. Penned by Justice Perlas Benabe, First Division. The constitutional authority, Mr. President, is very clear. Now, let's put that aside for a moment. But we're not allowed to do that. But for a moment, let's put that aside, that the Constitution is not clear and does not tell us what to do. The rules of the Senate says that any amendment should be presented a day before. And that's why the then minority, when I was Senate President, walked out, because your contention was, when we gave it to the Committee on Rules, kahit mahigit isang araw na at binabalik ng rules, we did not follow the rules. So on the rump session or alleged rump session on June 3, first of all, you did not have a quorum of 13. But let's assume for the sake of argument, I'm not giving you that point. As far as I'm concerned, it's in the Supreme Court, walang quorum on 12. Assuming may quorum on 12, you did not follow the rules. There was not a one-day notice for the rules. And then if you look at the records, this impeachment court adopted the rules on May 18. So that means that it is this impeachment court that now has to adopt any amendment to the rules. We did not debate that amendment to the rule. We cannot now just change the rules. We're here for the opening statements. We're here for the trial. Are we here to change the rules? We're changing the rules here today, Mr. President. So, Mr. President, later on I'll ask permission to talk about yung two-thirds, because both the issue of the presiding officer and the issue of what constitutes two-thirds of all members is a threshold issue. Para maintindihan lang po ng lahat, lalo po sa mga kababayan natin na nanonood, Merriam-Webster, simple definition, a threshold issue is a preliminary question, minimum requirement, or foundation condition that must be met or resolved before proceeding to the substantive merits of a case, project, or process. In this initial criteria, if this initial criteria is not satisfied, further action is typically dismissed or halted. I want to avoid that this impeachment trial will be declared null and void. I want to avoid walkouts. I want to avoid any delays, Mr. President. The Senate President is more than capable. He said he is willing. He said he is ready. He has been in many situations in his life that people say you cannot do it, but he is done well. He has studied. So what is the issue? Why do we have to vote for a presiding officer, Mr. President? Why can't we follow the Constitution? So the point of order, Mr. President, is that amending the rules, implementing a null and void rule, and violating the Constitution will endanger this whole hearing, Mr. President. So please rule on the point of order, and I hope that the Senate President, who is more than able, will preside.
Thank you to the gentleman from Taguig. Before I express my views on the matter, let me just put into the record the facts on when we amended Rule 2 of the Rules of Procedure on the impeachment trials. On June 3, 2026, Senator Juan Miguel Zubiri proposed Senate Resolution number 430, and that was adopted during that time. And then, on the same day, the same resolution was adopted and renumbered to Resolution number 40. It was published on June 9, 2026, in the Philippine Daily Inquirer, as well as Malaya. During that time, in June 3, when we amended the rules, everyone had the opportunity to express their views regarding the proposed resolution. And since no one objected, we adopted Resolution number 430 and renumbered it to Resolution number 40. That is anchored on our Constitution, Article 6, Section 3, Paragraph 8 of the Constitution, that the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So my view to the good gentleman, let me just finish, sir. My view is this resolution has been duly approved, and everyone was given an opportunity to discuss that, to object. However, it was no one objected to that resolution, and it was duly approved by the body. So any discussion regarding this resolution should be discussed in plenary when the Senate convenes as a legislative body. In the past precedents, during the ERAP impeachment, November 15, 2020, the body as well approved the rules of impeachment in plenary. During the Corona impeachment, March 23, 2011, once again, resolution number 39 was adopted in plenary. So any issues pertaining to this resolution should be discussed in plenary when the Senate convenes as a legislative body. So that is the position of the chair and the view of the chair on this matter.
Sir President, first, may I dispute that you used the word fact. It is not a fact that the rules were changed because it is being disputed that first, there was no quorum at that day. Second, if we are going to amend the rules of impeachment for the impeachment trial in plenary under the rules of the Senate, Section 136, second paragraph says, the rules may be amended by means of a motion that should be presented at least one day before its consideration. It was not presented on June 2. So we did not follow our rules. So a rule that was passed that did not follow our rules, or amendment that was passed that did not follow our rules, is void. You cannot get anything out of it. It is a nullity. So if today we pass a change in our rules and we do not follow our own rules in changing that rules, we cannot follow that rules. Secondly, Mr. President, the impeachment court already adopted our rules. Iba po ang plenary, tama po kayo doon, I agree with you there. Iba po yung impeachment court. So is the impeachment court now hostage or subject to whatever changes the legislative body does and we will not adopt? Then why did we adopt the rules when we took our oath? We adopted it because the impeachment court is not powerless to talk about our rules. But finally, Mr. President, for the sake of argument, just for the sake of argument, wag na natin tignan yung mga amendments. It's against the Constitution. So can the impeachment court disobey the Constitution? If the Constitution says the presiding officer should be the Senate President, can we now say na no, pagbotohan natin kung sino? Because if we say that we can, what next? Will we add to the articles of impeachment? Will we lower the bar of the quantum of evidence needed? Will we say that baliwala na yung pre-trial brief at bahala na si Batman? So, Mr. President, I thought that's why we have the rules. Because when we have the rules, it dictates fair play. And the rule says it is the Senate President who will preside. So if now we're not going to follow the rules, anong pinag-uusapan natin patas? Anong pinag-uusapan natin due process? Anong pinag-uusapan natin na fairness? It is who we chose as Senate President is a political. So we made our case doon na we would have a more fair. You made your case, you got the majority. Now you got the majority, we will give you all the support, Mr. President. But we have to follow the Constitution. We cannot have a trial where we do not follow the Constitution, Mr. President. I think pinaka-basic po yun. Saan sa Constitution po nakalagay, Mr. President, that ang nakalagay dito po, only in case the President. Let me give you a hypothetical. God forbid, God forbid. God forbid may mangyari sa Pangulong Marcos, maging Pangulo ngayon po, si Sara Duterte. My view is tuloy yung impeachment. Pero, ang magpre-preside na yung Chief Justice. O pwede ba tayo magbotohan na wag yung Chief Justice ang, wag yung Chief Justice ang mag-preside? So how is it possible that today, we're starting out on the wrong foot by arguing who will preside when the Constitution already settled it, Mr. President? So I appeal to my colleagues. There are a lot of accommodations, there are a lot of things, may bigayan talaga dito. May botohan, may caucus, may in-camera discussions. Pero pagdating kung sino magpre-preside na malinaw sa konstitusyon, wag na natin pag-awayan yon. The prosecution is here. I think they're ready. The defense is here. I think they're ready. Let's give the Filipino people, a fair trial. Hindi po fair kung pipiliin natin kung sino ang kahit sinong magaling, kahit ako piliin nyo. Hindi ko po tatanggapin yon kasi mali po yon. Hindi po yun ang nakalagay sa Constitution natin. Very, very clear po sa records ng Constitutional Commission. Walang makaka-amend doon. We are not given any latitude on this matter, Mr. President. I appeal to you, Mr. President. This is your Senate presidency.
Thank you. Thank you for that, those views to the good gentleman from Taguig. Kanina po, nabanggit ko ho na in my manifestation as the Senate President, that resolution number 39 or the rules of procedure on impeachment trial as amended shall continue to apply. So in other words po, rin-recognize ho nitong impeachment court yung amendments na ginawa ho natin noong June 3. At kagaya ho ng nasabi ko kanina, the humble view of this presiding officer is if there are any discussion on resolution number 43, as adopted as resolution number 40, it should be done in plenary. Because doon ho natin in-amend doon ho natin in-adopt yung impeachment, rules of impeachment, doon rin ho natin inamendahan. At nabigyan naman po ng oportunidad ang bawat isa para magkomento, magbigay ng pahayag, magbigay ho ng kanilang legal opinion. Pero at that time, wala naman po ang nag-object at inadapt po ng Senado in a legislative body. So the position of the chair, if there are any comments, any legal opinions, any issues, it should be done through the legislative body of the Senate.
Mr. President, there is no conflict, Mr. President. With your permission, Mr. President. There's no conflict. If you want to discuss it, in 3 weeks may session na tayo. So all we have to do today is follow the Constitution. You preside. Then pagdating ng plenary, then we can debate whether we are allowed to amend the Constitution or not. Because, Mr. President, that's why I premise this not as a parliamentary inquiry or as a point of information or whatever we may call it. That's why it's a point of order. A higher point of order than the point of order in the rules is a point of order in the Constitution. The Constitution says it is the Senate President who will preside. So are we saying now, Mr. President, that the rules can amend the Constitution? Is that the ruling of the chair?
Before I make my final ruling on this matter, may I recognize the gentleman from Pampanga, Senator Kiko Pangilinan.
Thank you, Senate President. Mr. President, with all due respect, the Constitution does not provide that the Senate President must preside in cases of impeachment trial. What the Constitution provides is that when the President is undergoing impeachment, going through the trial, is being tried, the Chief Justice must preside. Nowhere in the Constitution, in the provisions on public accountability and impeachment, does it say that the Senate President must preside when the Vice President is under trial or any other impeachable officer. And precisely because of this, and precisely because the Constitution likewise allows Congress, not the impeachment court, Congress, to promulgate its own rules, which is what the Senate did in June 3. We proposed amendments to the rules under our rulemaking power, which, by the way, was subsequently ratified when we convened in a special session on June 17. The June 3 journal was ratified unanimously on June 17 when we had our special session. And in the June 3 minutes and the journal, precisely, we approved the amendments to the rules. This was further ratified on June 17. Therefore, it is considered regular. The presumption of regularity now comes into force. But having said that, Mr. President, the good gentleman from Taguig has brought this matter before the Supreme Court. And we agree with the point earlier raised by the Senate President. This matter should be either discussed in the Senate in plenary as a legislative body, or if he has questions which may in fact turn out to be valid, he has brought this matter before the Supreme Court. And therefore, this impeachment court is not the venue for this debate, Mr. President. If there is anyone who is out of order, with due respect, I think the proper process is the matter is pending before the Supreme Court. There is no temporary restraining order. There was a request for a status quo ante order. It was not granted. And therefore, the presumption of regularity behooves us as an impeachment court to proceed. And finally, Mr. President, allow me to reiterate, the point of order is improper. In fact, the debate on this matter here in the impeachment court is out of order, Mr. President.
Sir
For the
President.
record.
Sir President,
So
before you decide, Mr. President.
the chair has already
Sir
ruled.
President, before you rule,
The chair has
Senator
already
Pia wants
ruled.
to ask for the floor.
Just
And
2 minutes.
may I respond to
May
Senator
I
Pangilinan?
allow the gentleman from Taguig to rebut for 2 minutes, and then we will make the final ruling.
Before I rebut, I'm from Ateneo Law School. And what they taught us there is that you look at the records of the Constitutional Commission. And then, pag klaro, klaro. But let's call someone from UP Law to see whether they were taught the same thing. Senator Pia, may I ask that Senator Pia be
We
recognized
recognize the
before I get my
gentlelady
2
from
minutes?
Taguig, Senator Pia Cayetano.
Thank you, Mr. President. It's not an Ateneo UP issue, but always happy to stand before our colleagues and share our experience in the UP College of Law. I was prepared to address this to all our members of the bar in the Senate, but since it is Senator Kiko, my schoolmate, my teammate actually in the UP volleyball varsity team who stood up, I'll also specifically address it to Senator Kiko. So, dear Senator Kiko and our colleagues in the majority, knowing that you have members in the majority that are lawyers, and for those who are not lawyers, you definitely have consultants who are lawyers. Wala naman siguro ni isang senador dito na walang consultant na abogado. Kahit ako abogado, ang dami ko hong staff na abogado din. Why? Because these are legal issues. We need to talk to the experts. Kung pag-uusapan natin ang mental health, physical health ng Vice President, then of course we will not listen to lawyers. We will listen to doctors, di ba? So this is a legal issue. Let's hear what the lawyers have to say. But let me just quote, because I know the Senate President doesn't have time to call on all the lawyers. So if you ask your lawyers in your staff, I'm sure nag-abala sila to look at the constitutional records, to look at the journal. I'm sure. And if they did not, please take your cell phone now and text your staff. What does the constitutional journal, the records of the debate show? Sinabi na po ni Senator Alan Cayetano, you can question him, you can doubt him. Ask your staff. May I ask you, dear colleagues, let's do our job well. The same way when you stand up and you tell me to do my job well and you disagree, I disagree with your point of view, I will listen intently to your point of view. And I'm looking at each one of you because this is our solemn duty. What does the Constitution say? Nakalagay doon, the Chief Justice, pag the President. Silent nga po sa iba. So sabi ng iba, at yan ang sinasabi ng Senate President natin na mukhang pwedeng iba. So we looked at what the constitutional framers said. What did they say? Nagdebate na po sila, colleagues. Nagdidebate tayo dito. Pag sinabi ng sponsor, ito na yung paliwanag, yung nag-i-interpolate at nagbibigay ng amendment, sinasabi niya, okay, yung pala paliwanag mo, okay na ako. No need to amend. Yun at yun din ang sinabi. Let's place ourselves in that position. Because that happens to us every day. Every day, somebody stands up and says, ano ibig sabihin nito? And the sponsor will explain. Pag hindi maliwanag, sasabihin nung nag-i-interpolate or nag-a-amend, ay, papa-amend ko kasi hindi maliwanag or I want to improve it. Pero kung nagkaintindihan naman, okay na. Eh, yun nga yung binasa. Tanungin nyo naman po yung staff nyo. Or let's pause, let's all get a copy. Let's show it. Because this is the foundation of this trial na tama yung nakaupong presiding officer. So that's my first point. Mag-abala naman tayo. Read it yourself, ask your staff to print a copy. In fact, on that note, may I ask Senator Alan's staff to print a copy and give it to all our colleagues. Mabilis lang yan, hindi na yan mapapatagalan. Show it. We can take judicial notice naman po siguro of it. Siguro naman, alam na natin ang ibig sabihin ng judicial notice. You can go to the actual records. Nandito na makakuha naman natin yun kung pagdududahan nyo yung ipapaprint ko. So that's my first point. My second point, Mr. President, is addressed to His Honor. If His Honor will insist that we have to call a regular session, we have to be in session to amend the impeachment rules, eh di tawagan niyo po ang Malacanang. Nagpa-special session naman po siya, di ba, with all due respect, to pass the National Orchid Law. To pass, what else? Ano, tatlo yun eh. Oo nga, yun nga, yung waling-waling as National Orchid, ano pa yung dalawa? No, I know, I'm not questioning it. I'm saying that there was a special session called to pass 3 laws. Naalala ko yung waling-waling because I love it. This is important. O ano pa yung dalawa? Unfortunately, hindi ko na maalala. Dalawang naturalization. Sports-minded po tayo. Love po natin yun. Nagkaroon ba ng laban between now and July para mag-special session tayo para doon? Hindi ko alam. But in any case, ito importante ito, di ba? E di kung pa-i-insist nyo na yung impeachment amendment na yan kailangan gawin ng special session, eh, mapapatawag tayo ng special session. Mukha namang very supportive naman ang Malacanang sa majority. Di ho ba? Pero I take the position that we are in impeachment court. We are already in impeachment court. Therefore, the amendments must happen here. Medyo common sense din naman po yan. I rest my case. Yun lang po. But as soon as the copies come, I will give it to you. Colleagues, Look at it, wag tayong majority-minority botohan. Ayusin natin yung pagboboto natin dahil pinapanood tayo, pinapaniwalaan tayo, at umaasa sa atin ang taong bayan. Maraming salamat po.
Once again, it is, again, before the chair rules, let me acknowledge a former Senate President, Senator Tito Soto.
Thank you, Mr. President. Tama-tama yung sinabi ng distinguished lady from Taguig. Tanungin daw yung mga legal staff. Binigay nga sa akin ng legal staff ko, eksakto ganito eh. Article 11, Section 6, page 154. Constitution is silent regarding presiding officer of Senate impeachment. However, the Constitution expressly provides that the Chief Justice will preside if President is on trial. O ngayon, yung mga graduate ng Ateneo at saka ng mga UP, ito ngayon yung legal maxim. Expressio unius et exclusio alterius. In other words, the express mention of one thing is the exclusion of another. Palagay ko, naintindihan nyo lahat ganyan. Itong akin, sa publiko yung sa akin. Ang sinasabi ng publiko ngayon, nanonood sa atin, dapat you should not resort in too much technicalities kasi ang public interest ang iniisip nila rito. They want to expedite the proceedings. They want the trial, not rules. They're interested in the trial, not rules. In the interest of justice, sabi nga nila, sometimes rules are not sacrosanct. But itong nangyayari ngayon dito, ang publiko ang importante rito. Where does the Constitution emanate from? From the public, from the people of the Republic. So, desisyonan nyo na to, Mr. President, para matapos na.
Sir President, can I have my 2 minutes?
Once again, let me reiterate the position of the chair. My humble position is that this matter should be discussed during plenary when the Senate is convened as a legislative body. And may I ask the gentleman from Taguig if he is objecting to this position?
Yes. I'm objecting to that position and will call for a vote. May I explain? I think under the rules I can explain why I'm asking
We'll
for a vote.
call for a vote first.
Mr.
And then
President,
we'll allow...
Mr. President, under the rules I can explain why I'm calling for a vote first so that I can convince them to vote for me.
No, under the rules,
When you object,
there's
Mr.
an objection. The vote will proceed without any explanation.
Mr. President,
and after that,
under the
we will
rules-
allow the gentleman from Taguig to explain his vote.
Mr. President,
So we call for
Mr. President,
a division of the House. So those who are...
Sir President, when you
Wait,
object, you're
those-
allowed to explain your objection and state
Senator
your objection.
Lacson is recognized.
Thank you. Your Honors, pursuant to Rule 2 of the Rules of Procedures on Impeachment Trials, as amended, I move to elect Senator Judge Francis Joseph Guevara Escudero as the presiding officer of this impeachment court.
Objection, Mr. President, and may I allow to...
We proceed
Objection,
to...
Mr. President, I'm allowed to object and I'm allowed to
Yes,
explain
you're
my
allowed to
objection.
object. You're allowed to object, but we will proceed
No, Mr.
with
President.
the division
Mr.
of the
President,
House.
point of
So
order.
those who are,
Point of order,
those
Mr.
who
President.
are in favor of the
Sir
motion
President,
of Senator
you're allowed to
Lacson,
explain para
please-
ma-convince mo nga yung
Please
iba.
raise your hand. We will vote by raising of hands. So those who are in favor of the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand. The clerk of court is directed to count the votes.
No, in our rules, parliamentary procedure.
How many? How many?
Explain my vote, Mr. President.
Hold on. Allow the chair to make a ruling. Those who are against to the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand. Ilan? The official count is 12 in favor, 8 against. The majority, those who are in favor, has it.
So, President,
The
may I
court
explain?
resolves to elect Senator Chis Escudero as presiding officer of the impeachment court. The duly elected presiding officer shall, under the same oath taken on May 18, 2026, immediately assume and exercise all powers, functions, duties, and prerogatives pertaining to or vested in a person presiding over the impeachment trial under the rules of procedure on impeachment trials, as amended, and shall give full effect to the powers inherent to the courts under Rule 135, Section 5 of the Rules of the Court.
Mr. President, may I now explain my vote?
You're allowed to explain your vote. You
Mr.
have 2
President,
minutes.
first of all, we cannot violate the Constitution. We put the whole impeachment trial at risk here. What Senator Tito Soto, former Senate President, what his staff did not tell him is that there is such a thing as procedural due process, and that who presides goes into due process and fairness. The Latin term that he mentioned was for enumerations, that when there are enumerations at hindi kasali doon, in this case, there was a statement that in only one case it would be the Chief Justice, because member of the Constitutional Commission who became Chief Justice Davide was going to amend precisely the Constitution to state the Senate President shall preside. But upon explanation by the sponsor that it is understood that it is the Senate President, then it should be the Senate President. And dun sa sinabi ni Senate President Soto that ang gusto ng tao ay mag-umpisa na, precisely, kanina pa dapat tayo nag-umpisa kung nag-preside ang Senate President. Secondly, this is when you have threshold issues, issues that go into due process fairness. If we're going to say that ang gusto ng tao i-convict na lang, then let's just blurt it out. Now, if we're going to say we want a fair trial, let's make sure that every aspect of this trial is fair. So that's why, Mr. President, if you read the rules, the presiding officer shall have the power to make an issue by himself or by the Secretary of the Senate all orders, mandates, writs, authorized by these rules of the Senate, and make and enforce such other regulations, orders, premises that the Senate may authorize or provide. Nandito din, Mr. President, that the Senate President may by himself, or bottom line, Mr. President, pwedeng mag-decide ang Senate President o sa atin. And Mr. President, there are issues that goes into fairness. You know, the AMLA will be a witness here. And I have information that the 20 years AMLA records of Senator Escudero and his credit cards and bank accounts were all opened up in the office of the Senate President, where members of the Blue Ribbon Committee was here. Then we're going to ask him to preside. So there's a problem with, this is my explanation. This is my explanation.
To the gentleman
This is
from Taguig.
factual and this is my explanation. So I will stop there.
With all due respect, your statement's already out of order. It has nothing to do with the topic on hand.
No, Mr.
And
President.
the presiding officer will strike off.
It has all to do with this.
Will strike off.
It has all to do.
The
I do not,
statements
Mr. President,
pertaining to Senator
Mr.
Escudero.
President, kaibigan ko si
I
Senator
direct the
Escudero.
stenographers to
I
strike
don't
off
doubt
these statements.
him. He is the victim here. I'm not doubting him. I'm not doubting he will be fair. I am saying, do we want a fair
suspend
trial
the
or not,
session
Mr.
for a few
President?
minutes to request the presiding officer, Senator Chis Escudero, to ascend the rostrum. Session
Mr.
suspended.
President, on this issue, still on this issue,
Standby. 3, 2.
Okay, I think now we can collectively exhale. That's not how we expected the first hour of the impeachment trial to proceed.
Yeah.
We were talking earlier about Win Gatchalian as Senate President being a very good presiding officer, but it turns out that they had a different plan all along. Right?
Yeah. I think they stuck with what Senator Lacson said when the new majority was formed a few weeks ago.
How do you think this will affect the trial from now on? Do we expect Chis Escudero to be marked to behave differently from last year, for instance?
Well, for the sake of the institution, he has to, because although he is a lawyer, I'm a lawyer, you're a lawyer, I mean, it favors us.
I'm not a lawyer.
Oh, okay. Sorry. I just assume. But it favors all lawyers that lawyer ang mag-preside dyan. Yung cloud kasi nang nangyari last year is something that he will be carrying into the role. And of course, whether we want to or not, that will also affect the credibility of the institution itself. So, it comes at a great burden. So, sa start pa lang, kailangan talaga mapalinaw niya sa mga nagdududa, mga skeptical from last year's experience. Now, this time, he will really be fair.
Let's take a look at the Cayetano siblings, no? Tag teaming the impeachment trial. Did they have a point?
That's the interesting part of that very long conversation. Let's start with the baseline.
Okay.
What does the Constitution actually say? The Constitution in Article 9 actually just says that when it is the President himself is under trial for impeachment, the Chief Justice will preside.
Okay.
And it stops there.
Yes.
So ang tanong kaagad, pag ako tinatanong ko yan sa klase, so sino magpe-preside based on what the Constitution says pag hindi presidente? The right answer there is, it could be anyone because the Constitution doesn't say anything.
Okay.
Ngayon, yung tinuturo ng magkapatid na Cayetano, na Senator Cayetano, that the records say that apparently during the Constitutional Commission's records, there was a conversation.
About this.
One of the commissioners said that, paano kung ganitong sitwasyon? It's not the President. May sumagot sa kanya, well, in that case, the Senate President will preside. However, as every lawyer also knows, if yung conversation na yon was not born or hindi sinulat sa contract, and the Constitution is the nation's contract, it doesn't necessarily hold kung mas malinaw yung kontrata na hindi naman sinulat doon.
And to the ordinary layman, there is no... they're making up a distinction.
Yes.
No?
Yes.
The Cayetano sibling.
Yes. Yeah, and then parang kaya nga medyo nagkakaguluhan because anong ba talagang tama sa mga abogado. Ganito yan. If the Constitution is clear that it is only when the President that the Chief Justice will preside and everything else is open to the Senate's impeachment court, you follow the text because the text of the Constitution follows.
Okay.
However, if the text of the Constitution is vague or ambiguous, tinuturo to sa law school. In fact, mga 10 years ko tinuro yung subject na to, legal method. When it is vague, when it is ambiguous, hindi natin maintindihan. That's when you go to the records.
But in fact, is this provision vague or ambiguous?
Not at all.
Hindi, di ba?
Hindi. Because when the Constitution is there to stop, prevent, or restrain government. If it does not stop, prevent, or restrain government, then it's not part of the things that government cannot do.
Okay.
So since wala sa listahan ng mga bawal gawin ng isang Senate impeachment court ang pumili kung sino magpe-preside, kung hindi naman presidente ang ini-impeach, hindi yan bawal. Ganun yun.
I don't want you to read the mind of Alan Cayetano, but do you think he really believes this? That it's a constitutional issue?
Well, we will know if he raises it to the Supreme Court, and I'm gonna be surprised because he did mention procedural due process because iba yung presiding ano. I think that's a bit of a stretch already because the presiding body is the Senate as an impeachment court.
Okay.
The presiding officer is tangential to that. It doesn't really go to the heart of due process.
Attorney John, we still have live pictures from the Senate. No, the session has been suspended, but we can see what's happening, although there is no audio. I think they are preparing the presiding officer to ascend the rostrum or whatnot.
Oh yeah, there he is.
I'd like to ask our audience, if you want to share your insights on what's happening, you can do so on the Rappler app. Join the impeachment trial chat room. I think we should have some very interesting conversations there. So I want to separate the two issues that I see. So one is, are the Cayetano siblings using this supposedly constitutional issue to delay or derail the impeachment trial? And the other issue is it in fact a good decision to have the majority vote for Chief Escudero as the presiding officer? So the two different issues, right?
Yeah. Well, on the first one, both of them are lawyers, and I think both of them practiced. So to be fair to both of them, in every trial, especially a high-stakes trial, if you have procedural questions about everything, you bring it out already. And then if not because you want to win the vote on the trial itself, but rather in preparation for an appeal, or maybe they're preparing to go up to the Supreme Court. So okay yan, but that's part of the battle, if we call it. So on the second thing naman, the majority voting for Senator Escudero as presiding officer, I'm really on the fence on whether or not that's the best way to proceed, considering that the institution itself. Oh, yan na.
I think, yes, we're ready to go back.
Mr. President.
What is the pleasure of Senator Judge Cayetano?
Mr. President, I'm explaining my vote.
The lady has 2 minutes.
Thank you. Dear colleagues, my explanation includes a reminder to all of you na kung di nyo kasundo si Alan, malamang kasundo nyo ako. So, if sarado ang pag-iisip nyo na si Alan nagpaliwanag, ako naman ang magpapaliwanag. Pagbigyan nyo naman ako. But what I'm saying is not new from what Senator Alan Cayetano expressed. And I have here copies of the constitutional verbatim debate on this provision. And as Senator Alan read, sinabi ni Mr. Monsod, is it not understood that when the President of the Philippines is on trial, it is the only time when the Chief Justice of the Supreme Court will preside? Is it necessary to say that the Senate President will preside during all other times? Ulitin ko yung tanong, kasi yun ang tanong natin today. Is it necessary to say in the Constitution that the Senate President will preside during all other times? Ang sagot ni Mr. Davide, Mr. Presiding Officer, I precisely presented that because we have a distinction when it comes to the Chief Justice of the Supreme Court. But with that clarification, that in all other cases, it would be the President of the Senate who will preside, I withdraw the amendment. Kaya clear sa Constitution that in all other cases, the President of the Senate will decide. Wala, hindi ho applicable dito yung excluso unos. Hindi ko na-memorize yan kasi I graduated in 1991 and we took that up in 1987, but the phrase is, pag hindi kasama, excluded. Hindi po applicable yon. With all due respect to our former Senate President, it is the intention of the framers that matter. I will ask the page to help me distribute this among our colleagues. I have also asked our staff to actually copy. I am environmentally friendly, so ayoko sana ng papel. Pero alam ko na hindi po lahat sa atin gumagamit ng digital, ng electronic gadgets, kaya pinapil ko na lang. Pero kailangan ko pakita sa inyo yung mismong nasa journal, yan din yon. Yan din yon, my dear colleagues. Yun lang hiling ko sa inyo, intindihan naman natin yung nandito. Bumoto na. Pero intindihan naman natin kasi this is just the first day. We cannot disregard the Constitution. And I continue, Mr. President. We have enough jurisprudence, more than enough, to explain to us, even in layman's term, what basic legal principles are. And one of the most fundamental principle of constitutional construction states that we give effect to the intents of the framers of the Constitution. With this vote, did we give effect to the intentions of the framers of the Constitution? Sinabi nga Senate President ang magpe-preside. Hindi na siguro napakalaking bagay yon dahil kahit sinong ipalit nyo, maayos naman ang mga kasama natin sa colleagues. Sa colleagues natin, maayos naman. Di ho yun ang point. The point is, what are we required to follow? That's why may Constitution. And I will now state, for the record, a few cases that point out that this is what we are supposed to do. Give effect to the Constitution. Lambino versus Commission Election in GR number 174153, the Supreme Court looked explicitly to the Constitutional Commission deliberation to determine the nature of people's initiative. Because the text was debated, the court used the framers' explicit intention. I repeat, the court used the framers' explicit intention revealed in the plenary debates to prevent deceptive or misleading petition processes and establish a stringent full text requirement. So anong ginawa sa kaso? Tiningnan ang intent ng framers of the Constitution. Another case, Calderon versus Carale, GR number 9163. God bless his soul. Si Dean Carale was my dean. And Senator Imis as well. Senator Kikos as well. He was with my father in the University of Michigan. So, pagbigyan niyo na ako a moment of remembering him. In GR number 91636, the court resolved a dispute regarding the President's power to make appointments without confirmation by the Commission appointment. The court examined the historical and textual context of Article 7, Section 16 of the 1987 Constitution, noting that the clear and express intent of its framers was to exclude presidential appointments from confirmation except for those expressly mentioned. So, balik ko sa kasong to. What was the clear intention? That the Senate President presides. That is the clear intention. Dear colleagues, umpisa pa lang. I beg all of you, makinig naman tayo. Masumunod naman tayo kung ano yung sinasabing trabaho natin. The Constitution, the intention of the framers, and then the clear construct. O, another case. Gold Creek Mining Corporation versus Rodriguez. This is a very old case. So yung mga binanggit sa inyo, bago-bago pa yun dahil si Dean Carale, buhay pa naman as of the pandemic. So 2,000 plus. Ito, 66 Philippines, 259. So for lawyers and law students, pag sinabing Philippines, pag yan yung ni-record, alam mo ng 50s, 1940s, something like that. Justice Jose Abad Santos articulated the definitive rule. The fundamental principle of construction is to give effect to the intent of the framers of the organic law and of the people adopting it. Dear colleagues, I can stand here and read more cases to all of us. We have law students. We have freshman law students, we have fresh graduate, we have bar reviewees listening to us. Tapos tayo pa lang, hindi natin mabigyan pahalaga ang very clear legal principles. Pati ang prosecution and defense nakikinig. Sana po, huwag niyong abalahin yung oras namin. Bigyan niyo naman kami ng maliwanag na mga arguments ninyo because we are willing to listen. Pero colleagues, patunayan naman natin that we are willing to listen. Hindi yung pagpasok natin, nag-prejudge na tayo. Kasi sad to say, mukhang ganon. I tell you, there will be times I probably will not vote with the minority because I believe tama yung sinasabi ng majority. Sana po, yun ang pakita natin sa taong bayan. So, hindi ko na abalahin yung time dahil kakaupo pa lang ng bagong presiding officer, pero ang dami pang kaso that says, look at the intent of the framers of the Constitution. And today, we disregarded the intent of the framers of the Constitution. Magandang hapon po, gaya ng pag-uumpisa ng hearing na ito.
We know the remarks of Senator P. in connection with their explanation of vote. What is the pleasure of Senator Judge Soto?
I'd like to explain my vote also, Mr.
The
President.
gentleman may proceed, and he has 2 minutes.
I have
Kindly
one
be
line.
mindful of the timer.
I have one line to say. That's the reason I voted in favor. Because the minutes of the Constitutional Commission are merely research source.
What is the pleasure of the Honorable Padilla?
Ginoong,
Will the gentleman explain his vote?
opo.
The gentleman may proceed. You have 2 minutes, sir.
Maraming salamat po, Ginoong punong tagapamahala. Mga mahal kong kasama, sa loob po ng 4 na taon na ako po ay ibinoto ng ating mga kababayan at nagsilbing senador, ako po ay naging tagapangulo ng komite ng Constitutional Amendments. At tuwing meron pong pagdinig, ang lagi po naming pinapatawag ay yung mga sumulat ng konstitusyon. Bilang sila po ang nakakaalam kung ano ang puso, ang diwa ng konstitusyon. Malinaw po na kung meron tayong pakikinggan, ay yung creator. Hindi po ba? Tayo naman po lahat ay naniniwala sa Panginoong Diyos, kaya tayo po ay naniniwala sa salitang creator, tagapaglikha. At ang lumikha po ng konstitusyon ay itong mga taong nabanggit sa ipinamahagi ng ating mahal na Senadora Cayetano. Malinaw po dito. Nasabi na po sa English ito. Mainam po ay sabihin po natin sa Tagalog upang mas maintindihan po ng ating mga kababayan. Bingi po ako ng tulong sa Google kasi legal terms po ito. Hindi naman po ako nagtapos sa UP, hindi rin po ako nagtapos sa Ateneo, nagtapos po ako ng criminology at UP rin sa University of Prison. Ang sabi po dito, sa Tagalog po Ginoong Presiding Officer, eksakto ko itong hinihain dahil nagkaroon tayo ng pagkakaiba pagdating sa punong mahistrado ng Korte Suprema. Ngunit sa paglilinaw na iyon, na sa lahat ng ibang mga kaso ay ang Pangulo ng Senado ang mamumuno. Kaya binabawi ko ang nasabing susug. Ang nagsabi po nito ay ang dating Justice Davide. Ngayon, mga mahal kong kasama, at sa ating po mga taga-subaybay, ang batas po ay precise. Hindi po ito pwedeng iba-ibahin o baluktutin. Kung ano ang sinabi lalo ng saligang batas, ay sana po ay panghawakan natin. Ngayon, sa loob po ng 4 na taong ko dito, lagi pong sinasabi yung tradisyon. Minsan, yung rules na yan, nawawala yan Ilang beses na ho ako naguluhan dito dahil, teka, sundin natin yung tradisyon kaysa yung rules. 2 beses na po nagkaroon ng impeachment. Yung unang impeachment, ang nag-preside ay yung Chief Justice, yung kay Pangulong Estrada. Yung sumunod po, nandito na po ako nun. Ang nag-preside ay ang mahal na Bicolanong kaibigan ko, Senador Chis Escudero. Yun po kasi yung nasasabi sa saligang batas at tradisyon. Yun na po yung nangyari. Ngayon, gusto ko pong tanungin yung mga kasama ko sa majority. Personal na tanong po ito. Nung hinihikayat po akong sumama sa majority, isa lang ang sinabi ko. Kung si Senator Chis Escudero ang kababayan kong Bicolano ang gagawin yung Senate President, lilipat ako sa inyo. Ang hindi ko maintindihan, bakit ngayon pinipilit natin ng ating presiding officer, si Chis Escudero. Ba't hindi natin siya ginawang Senate President noon? Yun lang po ang tanong ko. Maraming salamat.
The remarks of the gentleman is noted. Senator Marcos, what is your pleasure, ma'am? The lady may do so. You have 2 minutes, ma'am. Kindly be mindful of the clock.
Yes, thank you very much. Ang sabi sa atin nung bata tayo, kapag mali ang umpisa, mali na ang lahat na susunod. Ayoko naman magkamali sa umpisa pa lamang na napakahalagang paglilitis na ito. Unang-una, paulit-ulit na nating sinaad na ang ating saligang batas ay hindi maaring baluktutin. At napakaklaro nito. At ang sinasabi ng ating Constitution of 1987, Article 11, Section 3, Number 6, all other impeachable officers ang sinasabi, carving out therefore the exception that proves that rule, that the Chief Justice is the single exemption, and otherwise the presiding officer should be the Senate President. It is the exception that proves the rule. Palibasa na uso ang Latin, may kabaliktaran din sa kinote ni Senator Soto, expressio unius est exclusio alterius. Palibhasa, hindi naman in-exempt, ibig sabihin na laging dapat ang Senate President ang presiding officer. Ikalawa, nakita naman natin ang mga debate, ang listahan ng mga sinabi at paliwanag nung dating Chief Justice natin, si Mr. Davide, nung panahon, nung convention. Contextual reading and the thorough debate do not allow for any interpretation whatsoever. And we should abide by that. Ikatlo, yung kaduda-dudang quorum nung June 3 na pinapaliwanag ng aming minority leader na hanggang ngayon nakatenga pa rin. Kung tutuusin, nung sinasabing na amyenda, yung Supreme Court petition ay pending pa, kaya hindi karapat-dapat na yon ang sundan. Ikalima, it's not the impeachment court but the Senate that amended the rules. Kaya para sa akin, napakaraming dahilan, wag sana nating sayangin itong napakahalagang responsibilidad natin at wag mag-umpisa sa mali itong paglilitis. Maraming salamat.
Thank you, Senator Marcos. Duly noted and entered into the records. The pleasure of Senator Legarda. Senator Judge Legarda, rather.
Thank you, Mr. Presiding Officer. Where the Constitution is
The
silent...
lady will explain her vote or make a manifestation.
It's a manifestation. Which,
The lady may proceed with
which
her
seems like
manifestation.
an
She has 2
explanation of
minutes.
vote. Thank you. Where the Constitution is silent, the intent of the framers should guide the choice of the presiding officer. Any departure from the traditional arrangement must be approached with caution, as it may place the validity and the legitimacy of the entire impeachment in doubt. Mr. Presiding Officer, I also respectfully place on record that there is a pending challenge before the Supreme Court involving the June 3rd Senate proceedings, including the authority of the body then that adopted Senate Resolution number 430. This manifestation is made to place on record that we are not yielding our position in the pending case and is without prejudice to the final determination of the Supreme Court. Thank you, Mr. Presiding Officer.
Thank you, Senator Legarda. The presiding officer would like to make a statement. Sa mga ginagalangan kong kapwa Senator Judge, sa ating mga minamahal na kababayan, sa mga partido sa kaso na kabinbin ngayon sa Senado, isa pong maganda at pinagpalang hapon sa ating lahat. Sa araw na ito, muling gagampanan ng Senado ang isa sa mga pinakasagradong tungkuling iniatas ng saligang batas. Ang pag-upo natin bilang isang impeachment court para litisin at husgahan ang pangalawang Pangulo. Kinikilala ng ating saligang batas na may mga opisyal na may hawak ng kapangyarihan at pananagutan na napakabigat para sa kanila lamang itinakda ang impeachment bilang tanging paraan para sila ay panagutin. Article 11, Section 2 of the Constitution enumerates these officials: the President, the Vice President, the members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman. They are not ordinary public officers. According to the late former Senate President Juan Ponce Enrile, they hold, quote, the highest and most sensitive offices of government. They may be removed from office only upon conviction for offenses of the highest constitutional gravity: culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of the public trust. Impeachment is a means to preserve constitutional government through the removal and disqualification, if so warranted, of an unfit official from a position of public trust. 5 opisyal pa lamang ang na-impeach ng Kamara de Representantes sa ating kasaysayan sa ilalim ng 1987 Constitution. Una, si dating Pangulong Joseph Estrada noong 2001 na ang paglilitis ay naungusan ng mga pangyayaring humantong sa EDSA 2. Ikalawa, si Ombudsman Mercy Gutierrez noong 2011 na nagbitiw bago pa man mabuksan ang kanyang paglilitis ng Senado. Ikatlo, si Chief Justice Renato Corona noong 2011 din na nilitis na patunayang nagkasala at inalis sa tungkulin ng impeachment court bilang punong mahistrado. Ikaapat, si dating COMELEC Chairman Andres Bautista noong 2017 bagamat nagbitiw siya sa pwesto bago pa man mapadala ang articles of impeachment sa Senado. At ikalima, si Vice President Sara Duterte noong 2025. Subalit ang nasabing articles of impeachment ay idineklara ng Korte Supremang null and void ab initio kung kaya't ito ay inarchive ng Senado. Siya ay muling na-impeach sa kasalukuyang taon at ngayon nahaharap sa paglilitis na ito. Ipinakikita lamang na maikling talaan ito na ang impeachment ay hindi isang pangkaraniwang kaganapan. Turing nga ng Korte Suprema, quote, it is the most difficult and cumbersome mode of removing a public officer from office. Subalit, ang paglilitis na ito ay hindi lamang hindi pangkaraniwan, ito ay tunay na bukod tangi. Bakit? Una, si Vice Presidente Sara Duterte ang kauna-unahang opisyal na 2 beses na na-impeach ng mababang kapulungan. Pangalawa, siya ang kauna-unahang Vice Presidente na haharap sa paglilitis ng isang impeachment court at pangalawang opisyal lamang na halal ng sambayanan na sasailalim sa prosesong ito. Pangatlo, siya ay hinahalal ng may pinakamalaking mandatong pinagkaloob ng sambayanang Pilipino sa sinumang kandidato sa ating kasaysayan. Mahigit 32 milyon o 61% ng kabuuang boto para sa ikalawang Pangulo. Pang-apat, ang articles of impeachment laban sa kanya ay inendorso ng 277 na miyembro na kumakatawan sa ating mga mamamayan mula sa iba't ibang distrito at sektor at ng ating bansa, na katumbas ay mahigit 80% ng kabuuan ng Kamara de Representantes. Terminating an elected mandate before the end of its term is among the most drastic acts our constitutional democracy can undertake. This is why the trial must be guided with prudence, tempered by caution, and marked with unquestionable impartiality. We must avoid even the appearance of impropriety and observe the cold neutrality of an impartial judge at all times. May I therefore caution my fellow senator judges, the prosecutors, the respondent, and their respective counsels and witnesses to refrain from making any comments and disclosures to the public pertaining to the merits of this trial as mandated by the impeachment rules itself. Let us heed the words of the Supreme Court that said, impeachment is not a chance to settle political scores. It is not a stage for political theater or personal attacks, because when the focus shifts to the person rather than the alleged wrongdoing, the process loses its integrity. As presiding officer, I shall do my part to uphold the fairness and integrity of this process and shall see it through to its proper conclusion. At this point, I would like to thank my colleagues for their trust and confidence. I did not seek nor did I ask for this responsibility, but neither will I shirk from fulfilling this duty without fear or favor. This now brings me to the threshold questions that will guide the conduct of this trial and the rulings of the chair. First, what is the number of votes needed to convict the respondent? Second, what is the quantum of proof required to sustain a judgment of conviction or acquittal in these proceedings? Third, how strictly or liberally will this court apply the rules in resolving questions of procedure and evidence? On the first issue, the Constitution provides that no person shall be convicted without the concurrence of 2/3 of all the members of the Senate. With 24 members of the Senate, a literal interpretation of this means that conviction requires the affirmative vote of at least 16 senator judges. This literal interpretation finds direct support in the 2000 case of Bayan versus Zamora, which concerned the Senate's compliance with the 2/3 vote required to concur in a treaty. Despite having only 23 incumbent senators at that time, then Senator Gloria Macapagal Arroyo was elected as vice president. Therefore, there were only 23 senators. The court held the charter provides that the Senate shall be composed of 24 senators. Without a tinge of doubt, 2/3 of the figure, or not less than 16 members, is an unquestionable compliance with the requisite number of votes mentioned in Section 21 of Article 7. It behooves, therefore, all of us to observe the same fidelity with the Constitution in this trial, which affects not only the mere ratification of a treaty, but more so affects the substantial rights of the respondent, as well as the sovereign will of the people as expressed in the overwhelming mandate given to her. This is the prevailing law today, and whether we agree with it or not, we must abide by it. However, those who disagree are not without recourse, because this is without prejudice to the right of any party who holds a different view to seek judicial relief. And should the Supreme Court, who possesses the sole authority to interpret the Constitution by virtue of its power of judicial review, render a different ruling on this question other than what the chair has stated, this court and this representation shall faithfully abide by that ruling of the Supreme Court. On the question of quantum of proof, given that impeachment is a sui generis constitutional proceedings, the standards of proof that govern administrative, civil, and criminal proceedings do not apply. However, this does not mean that senator judges shall rely solely on their conscience in deciding this case. No less than the Supreme Court also said that, quote, decisions regarding whether to acquit or convict must be based upon clear charges supported by sufficiently clear and convincing evidence. Furthermore, let me be clear that the burden of proof in these proceedings rests upon the prosecution. It does not and will not shift. The respondent is afforded the presumption of innocence and has no obligation to disprove the charges against her. Finally, we turn to the application of the rules of court in these proceedings. Rule 1, Section 6 of the Rules of Courts provide that the rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. We are also guided by the Supreme Court's Bench Book for Trial Judges, which reflects a long-standing principle of adjudication. In case of honest doubt about the admissibility of evidence, it is a better policy to rule in favor of admission and let the senator judges decide whether to give it little or no weight when deciding upon the case in the final outcome. But let me be clear. A liberal construction of the rules is not a license to ambush the opposing party, bypass due process, or introduce unverified evidence that would prejudice the fair and orderly conduct of this trial. Accordingly, consistent with the demands of due process, fair play, and the orderly administration of justice, the chair will construe the rules liberally so that, number one, the prosecutors may be able to adequately present their case, that the respondent may be able to rigorously test it. Number three, that the senator judges may be able to weigh the evidence for themselves. And fourth, so that the Filipino people may hear the whole and impartial truth regarding the allegations against the Vice President. Let us remember what our oath requires us, to do impartial justice according to the Constitution and the laws. Hindi po tayo nandito upang itaguyod ang anumang pampolitikal na adyenda. Hindi tayo narito upang paglingkuran ang kagustuhan ng alinmang panig. Narito tayo upang alamin ang katotohanan at sa pamamagitan nito, mapairal ang hustisyang walang kinikilingan. Ang tungkulin natin bilang mga hukom ay hindi maaaring talikuran. Sa gitna nito, batid ko ang mga problemang kinakaharap ng ating bayan na patuloy natin dapat pa ring pagtuunan ng buong pansin at hanapan ng solusyon. Tayo ay mga senador bago tayo umupo bilang mga hukom at mananatili tayong mga senador na patuloy na magsusumikap na tugunan ang mga pangailangan ng ating mga kababayan bilang Senado at hindi mababago ito. Kaya't aking hiling at dalangin na huwag sana malunod ang diwa ng pagkakaisang nagpigil sa atin gaano mang katindi ang mga debate at pagtatalo sa hukumang ito. Dahil anuman na magiging kalabasan ng paglilitis na ito, laging kinakailangan ang Senadong nagkakaisa. Dalangin ko po na sana pagkalubad tayo ng katatagan, karunungan, pagpapakumbaba at pag-unawa upang magampanan nating lahat ang ating tungkulin bilang mga hukom. Pagpalain na po lahat sana tayo ng poong may kapal. Maraming salamat at magandang hapon po.
Sir Presiding Officer.
Before we continue, Chair would like to make of record that Senator Joel Villanueva will insert his explanation of vote into the records. If there are no objections, Chair dispenses with the reading of the minutes of the Journal of the May 18 Proceedings, 2026, and consider the same as approved. On the motion? There being no objection, Journal is hereby approved. Senator Cayetano?
Mr. President, let me thank you and just make the manifestation that this representation believes that it is a threshold issue, the number of senators to convict, and two-thirds, the logical, fair, that would give justice to the Constitution 16. So I thank you for that statement. And as you mentioned, it is a statement of the court, not only of the presiding justice, because napaka-importante na sa umpisa pa lang, alam na ng prosecution at alam na ng depensa kung ilan. Having said that, Mr. President, as to the issue of the presiding officer, not to take up more time, I'd like to register a continuing objection, but instead of giving my arguments, may I submit it in writing, with basically saying that violation of the Constitution is not a technicality. But if our dear colleagues would allow, we will just submit it in writing, Mr. President. Whoever wants to join.
The continuing objection of the gentleman is noted, and he may so submit his extended written explanation in writing for the record. Senator Cayetano?
Thank you, Mr. President. Just a few administrative matters with your indulgence, dear colleagues.
The lady may proceed.
Thank you. I read that we have rules for our resource panel and also our prosecution and defense that no drinks and food allowed. May I respectfully request that they be allowed to have water. It's a basic human right naman siguro na makainom ng tubig. I read something. I'm just saying, I saw it in the rules. So I'm making clear because knowing them, they will follow our rules, and I think it's not right to not allow drinks. And then, there may be some who are pre-diabetic or diabetic and need to eat something. So, if they have to have crackers or whatever it is that they need to have, I think we should allow them to do that, Mr. President. Sama-sama ko na yung rules ko, ha. And then they should also be allowed to have a bathroom break. I don't want them to also, may ibang klaseng sakit naman yung hindi nakakapunta sa banyo, so may automatically be allowed. I think they're responsible enough to, they're a whole team. There's like a dozen of them here. And then finally, sitting is the new smoking. May we also allow them without them having to ask for permission to stand up, stand in the back, and to stretch their legs, because it is not healthy to be sitting down for 2, 3, 4 hours, and I think our hearings will go on for a long time. So that is my humble submission for the health and wellness of our prosecution and defense panel. Thank you, Mr. President.
Noted, and we will discuss the matter with the parties. Senator Pangilinan.
Yes, Mr. President, if I may be likewise allowed to submit a written explanation of my vote, particularly on the matter of referring to the Constitutional Commission when the debates of the Constitutional Commission, Mr. President, where I believe there is a contrary opinion, which the Supreme Court, in fact, ruled in previous rulings, the Chavez case, Mr. President, for the records.
Noted, the gentleman may do so. If there are no other matters, we now proceed to trial. The clerk of court will please call the case before this impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances for the prosecution.
Good afternoon, Your Honors. We are 11 House prosecutors and 15 private prosecutors. I am Representative Jervil Jinky Pitrix Luistro, appearing for the prosecution. We are ready, Your Honor.
May we get the names of the other panel of prosecutors as well as the counsel for prosecutors one by one for the record?
Good afternoon, if Your Honors, please. We have already submitted the names of the public and private prosecutors who have formally entered their appearance. Ako po si Representative Jose Manuel I. Diokno, magalang pong humaharap sa Senate Impeachment Court. Ready po.
Noted.
Good afternoon, Your Honors. I am Representative Laila de Lima from the Mamamayang Liberal or ML party list, respectfully appearing as public prosecutor. We're ready.
Good afternoon, Your Honor. I am Congressman Joel Chua, respectfully appearing for the public prosecutor representing the 3rd District of Manila.
Good afternoon, Your Honors. I am Arlene Kakabagaw from the Nagat Islands, representing the public prosecutor, Your Honor.
Good afternoon, Your Honors. I am Representative Lawrence Rivera Defensor from the 3rd District of Iloilo, respectfully appearing as public prosecutor.
Good afternoon, Your Honors. Representative Jonathan Keith Flores of the 2nd District of Bukidnon as public prosecutor, Your Honor.
Good afternoon, Your Honors. Representative Isabel Maria Jorge Zamora from the Lone District of San Juan City as public prosecutor.
Good afternoon, Representative Terry Don of Bicol Saro Party List. We are ready, Your Honor. Maraming salamat po.
Good afternoon, Your Honors. Representative Ramon Rodrigo L. Gutierrez of One Ready Party List, respectfully entering appearance for the public prosecution.
Good afternoon, Your Honors. Representative Lordans One of the 1st District of Cagayan de Oro City, respectfully appearing for the prosecution.
For the record and for the information of our prosecutors, the term used in our rules for the public prosecutors, as you so mentioned, should be panel of prosecutors of the House of Representatives, and insofar as I've been hearing the term private prosecutors, the private lawyers will be referred to as counsel for the prosecutors. You may proceed.
Good afternoon, Your Honors. I'm Attorney Lorna. Good afternoon, Your Honors. I'm Attorney Lorna Pataho Kapunan, counsel for the prosecutors, under the control and supervision of the panel of prosecutors from the House.
Magandang hapon. Ako po si Attorney Amando Virgil D. Ligutan ng Sapayan Lim Alvarez and Ligutan Law Offices or sa Legal Law from Cebu City. We are under the direct control and supervision of our honorable prosecutors from the House of Representatives. Ready, Your Honor.
Good afternoon, Your Honors. I am May Sancho Divina Gracia of the Co and Divina Gracia Law Offices, and I am respectfully entering my appearance as counsel for the prosecutors.
Your Honors, good afternoon. I'm Attorney Lino Chris Patao Kapunan, respectfully appearing as counsel for the prosecutors, acting under the direct control and supervision of the panel of prosecutors of the House of Representatives.
Good afternoon, Your Honors. Attorney Sonia Castillo, private prosecutor, under direct control and supervision of the public prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. Attorney Dina Melissa Lorenzo Singyan, for counsel for the prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. I'm Attorney Marford T. Fua, appearing as counsel for the panel of prosecutors. Good afternoon. We are ready, Your Honor.
Good afternoon, Your Honors. I am Attorney Erwin G. Matib, respectfully appearing as counsel for the prosecutors. We are ready.
Good afternoon, Your Honors. I'm Attorney Justine Lamarca, respectfully entering my appearance as counsel for the prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. With respect, James Brian Ibrahim Ali of Pecca Barlo, formerly Ponce Enrile Reyes and Manalastas, appearing as counsel for the prosecutors. We're ready to proceed today, Your Honor.
Good afternoon, Your Honors. I'm Attorney Reynaldo Robles of the law firm of Chan Robles and Associates, appearing as counsel for the prosecutors under the control and supervision of the public prosecutors. Ready, Your Honor.
Good afternoon, Your Honors. Bettina Nepomuceno Zamora, respectfully appearing as counsel for prosecutors. We are ready.
May it please the Court, Attorney Theodore Duterte, appearing as counsel and under the control and supervision of the House panel of prosecutors.
Good afternoon, Your Honors. Attorney Benjamin Sigua Tolosa Jr., respectfully appearing as counsel for the prosecutors, acting under the direct control and supervision. The prosecution is ready, Your Honors.
No other entry of appearances? That's it? How many in all, Representative Luistro? 11 on the part of the House insofar as the panel of prosecutors is concerned, and?
We understand, Your Honor, that only 13 private prosecutors entered their appearance today. Nevertheless, Your Honor, as manifested by the Honorable Jokno, the written entry of appearance has been filed already with the Honorable Impeachment Court.
Nevertheless, as they appear or will be participating in the trial, kindly inform them to enter their formal appearance during the trial.
Your Honor, the entire 15 private prosecutors have filed already their written entry of appearance with the Impeachment Court. The articles of impeachment will be presented by 4 separate teams, Your Honor, and that explains why the House prosecutors, or the panel of prosecutors, are joined by 15 private prosecutors, Your Honor.
Noted. Thank you, ma'am. Senator Cayetano, what is the pleasure of the lady from Taguig?
Yes, Mr. President, I just have a question for the prosecution panel. I understand that there is no requirement for the members of the House who form part of the prosecution to be lawyers. But may I know if they are all lawyers, and if some are not, may we know who are not lawyers? Thank you.
Your Honor, all the 11 House prosecutors are members of the legal profession.
Does that satisfy the Senator Judge?
Yes, I was just curious, Mr. President, because it's not a requirement, so I was just curious if, in fact, they are lawyers. Thank you.
Duly noted. The response of the lead prosecutor is duly noted.
Your Honor, may I just enter a correction to the earlier manifestation?
The lady may proceed.
Instead of 13, 14 private prosecutors are able to enter their appearance today. Nonetheless, all the 15 have filed their written entry of appearance with the impeachment court, Your Honor.
Noted. Appearances for the respondent.
Good afternoon, Your Honors. I am Sheila Sison, respectfully appearing for Vice President Sara Duterte. With the permission of the court, my co-counsel will enter their respective appearances.
You may proceed.
Gregorio Y. Narvasa II.
Christine R. Ferrer for the Vice President.
Good afternoon, Your Honors. Michael Wesley Poa for the Vice President.
Good afternoon, Your Honors. Carlo Joaquin T. Narvasa for the Vice President.
Good afternoon, Your Honors. I am Mark C. Vinluan for the Vice President.
Good afternoon, Your Honors. Justin Nicole B. Goulart for the Vice President.
Good afternoon, Your Honors. Lyndon Miguel C. Bacuel for the Vice President.
Good afternoon, Your Honors. I am Ralph Borja Bodota for the Vice President.
Good afternoon, Your Honors. Roberto Narvasa Batungbakal for the Vice President.
Good afternoon, Your Honors. David Runel M. Gully VII for the Vice President.
Good afternoon, Your Honors. Carol Grace G. Oroseo for the Vice President.
Good afternoon, Your Honors. Clarlene Radok for the Vice President.
Good afternoon, Your Honors. Francesca Marie V. Flores for the Vice President.
Good afternoon, Your Honors. Miguel Carlos Albar Fernandez for the Vice President.
Chair notes the entry of appearance of the counsels for respondent Vice President Sara Zimmerman Duterte, and Chair likewise notes that the Vice President is not physically present but represented more than adequately by her counsels who entered their appearance. On May 19, 2026, the court, pursuant to Rule 7 of our rules, issued the summons to Vice President Sara Zimmerman Duterte to answer to the articles of impeachment. On May 20, 2026, the Sergeant at Arms served the summons on the Vice President and made a return of service under oath before the Secretary of the Senate. Let the return be entered at large into the records pursuant to Rule 8 of the Rules of Procedure on Impeachment Trials. So ordered. Likewise, the court received pleadings, comments, manifestations filed by the parties. All such pleadings, comments, manifestations, and requests filed by the parties, as well as all issuances and orders of the clerk, as well as the clerk of court, made through the presiding officer, are hereby deemed read into the records of the case. So ordered. At this juncture, the chair would like to direct the parties to prepare for their opening statements. We will start with the prosecution. May I know from the prosecution who will deliver the opening statement, and from the respondent who will deliver the opening statement? Under our rules, only one lawyer shall deliver the opening statement for either side. I presume, Representative Luistro, you will deliver for the prosecution and for the on the part of the respondent?
I will deliver the opening statement for the defense, Your Honor.
Representative Luistro from the panel of prosecutors of the House of Representatives is now recognized to deliver her opening statement for the prosecution. You may proceed, ma'am, and you have 15 minutes.
Your Honor, before I proceed, the prosecution respectfully moves for the reading of the 4 articles of impeachment and the entry of the corresponding answer or plea for each article of impeachment, Your Honor. Your Honor, this is consistent to the Senate rules on impeachment, particularly Rule 7, Your Honor, the last paragraph of which mentions about failure to appear, failure of the lawyer to appear, and failure to file answer. There should be an entry of plea of not guilty. Likewise, Your Honor, under Rule 9 of the Senate Rule of an Impeachment, which says that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. In this rule, Your Honor, it was likewise provided that the name of the person appearing in behalf of the respondent should be entered into the record. And by the answer, Your Honor, it is humbly believed that it pertains to the particular plea of whether guilty or not guilty of the respondent, Your Honor. Likewise, Your Honor, under Rule 21, Your Honor, the trial of all the articles of impeachment shall be completed before the senators vote on the final question of whether or not the impeachment is sustained. It is gleaned from these rules, Your Honor, that the senators will be voting on a per-article basis, Your Honor. And that is why it is the humble submission of the prosecution that there should be reading of the article and entry of the particular plea per article, Your Honor. This likewise, Your Honor, manifests our complete adherence to the mandate of the Constitution sa pagbasa po ng mga artikulo ng impeachment at pagpapasok ng sagot ng respondent, maipakita po natin sa sambayanang Pilipino ang ating pagsunod sa mandato ng Konstitusyon. Likewise, Your Honor, it upholds due process not only of the respondent, but also of the Filipino people. Sa pagbasa po ng mga artikulo ng impeachment, she will be informed of the nature of the accusation against her bago pa po siya sumagot whether she is guilty or not guilty, Your Honor. Likewise, Your Honor, ang 4 na artikulo po ng impeachment ay nakabase sa iba't ibang alegasyon ng facts at iba't ibang nature of accusation or cause of action, Your Honor. And with that, Your Honor, it is perceived that there is a possibility that the plea of the respondent to each and every article will be different from one another, Your Honor. And lastly, Your Honor, this is consistent with the Senate rules on impeachment because the senator judges, the honorable senator judges, Your Honor, will be voting on a per-article basis after the conclusion of the trial of this impeachment case, Your Honor.
The chair will respond. Unless the counsel for respondent would like to say something about the motion of the distinguished lead prosecutor.
Yes, Your Honor, may I comment?
The lead, you may proceed.
Before the presiding officer can rule on the motion or request of the lead prosecutor. But before I give my comment, may I just clarify if the lead prosecutor is now making a motion to arraign the respondent accused.
Your Honor, whether this is arraignment or otherwise, the motion of the prosecution is very much consistent with the Senate rules on impeachment.
I think the question, Your Honor, is very simple.
As I have
It's
mentioned, Your
answerable by
Honor,
yes or no, Your Honor.
Rule 7,
Is the lead prosecutor,
Rule 9,
is the lead prosecutor
Let this not be a debate between the
requesting
counsels.
for the respondent accused to
Counsel
be
for
arraigned, Your Honor?
respondent, kindly make your comments and avoid asking questions from the counsel for the prosecutor. We will recognize the counsel for respondent for her comments on the motion and the manifestations made by the lead prosecutor for the House. You may proceed, ma'am.
Thank you, Your Honor. I believe I have a standing question to the lead prosecutor, and I would like to ask her for the legal basis for requiring the respondent to be arraigned today. Because, Your Honor, I note that in her request earlier and manifestations given for the respondent to be arraigned today, she cited Rule 7
Rule 9 and Rule 21. However, in Rule 7, it very clearly states that if the person impeached after service shall fail to appear either in person or by counsel on the day so fixed, or appearing shall fail to file his answer to such articles of impeachment, the trial shall proceed nevertheless as upon a plea of not guilty. Well, this rule is clear. It does not talk about any arraignment. And if we take a look at this sentence, everything here has been satisfied. The respondent accused is here, has attended through counsel. She may not be in person, but the notice given to the defense is that she may appear through counsel. Second thing is that the respondent accused was also able to file her answer. And so Rule 7 does not support the request of the lead prosecutor that the respondent accused be arraigned today. Now, on the matter of Article 9, counsel also say that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. And if he or she appears, or any person for him or her, the appearance shall be recorded, stating particularly if by himself or by agent or counsel, naming the person appearing in the capacity in which or he appears. If he or she does not appear, either personally or by agent or counsel, the same shall be recorded. And for all intents and purposes, respondent is present today through counsel. There is also nothing in Rule 9 that requires the reading of a 23-page articles of impeachment, which will be a waste of judicial time. Now, finally, under Rule 21, Your Honor, may I just correct the manifestation earlier by counsel, because it would seem to me, unless a reading of the transcript would say that I'm mistaken, but I seem to have heard the lead prosecutor claim that the voting on the articles of impeachment will be per article. Well, that's true, but the first sentence of Rule 21 says, the trial of all the articles of impeachment shall first be completed before the senators vote on the final question on whether or not the impeachment is sustained. Now, honestly, I do not see how Rule 21 is related to the motion now being requested or propounded by the lead prosecutor. And at any rate, Your Honor, given that the respondent is represented by her counsel today, and this is consistent, her appearance is consistent with the notice given and in accordance with the rules on rules of procedure of this court, then we can enter her plea on her behalf.
The arguments of the parties are duly noted. Chair will now make its ruling. The articles of impeachment were deemed read and spread into the records when it was referred by the Senate to the Committee on Justice for the proper issuance of summons. And a plea of not guilty will only be entered in accordance with our rules in behalf of the Vice President if she does not file an answer. But in this case, she has filed an answer and in fact has appeared through counsel. Insofar as the reading of the articles of impeachment is concerned, it will be done at the final resolution of this case when it is put to a vote by the senator judges, where each article of impeachment will be read before a vote shall be taken thereon. For those reasons, the motion is denied, and the lead prosecutor, Representative Luistro, may proceed with her opening statement. Kindly be mindful of the clock, and before recognizing you, ma'am, may I remind the counsels for the parties to kindly address the chair with respect to anything and everything they want or wish to say before the court, and not to address each other. The lady may proceed. Representative Luistro, you are recognized, and you have 15 minutes for your opening remarks.
We thank the court, Your Honor.
Mr. Presiding Officer, the Honorable Cheese Escudero, the Honorable Senate President, Honorable Win Gatchalian, sa atin pong mga kagalang-galang na Senator Judges, mga minamahal na kababayan, sa loob ng bulwagan o sa labas man, mga nakatutok sa telebisyon, sa cellphone o sa radyo, saang sulok man ng mundo, kayo naroroon. Maraming Pilipino ang nagtatanong ngayon, bakit mahalaga ang paglilitis na ito? Ano ang kaugnayan nito sa buhay ng ordinaryong Pilipino? Lubos po naming nauunawaan ang mga tanong na yan. Sa katunayan, may isang driver na nagtatanong, paano sasapat ang kita sa pasada upang mapakain niya ang kanyang pamilya? May isang OFW na nagtatanong, hanggang kailan kailangan lumayo upang mapaaral niya ang kanyang mga anak? May isang guro na nagtatanong, paano pagkakasyahin ang kanyang sahod sa dami ng utang na hinuhulugan? May isang manggagawa na nagtatanong, hanggang kailan magtitiis sa pansamantalang trabaho at kakarampot na sweldo? Sa unang tingin, maaring sabihin na malayo sa buhay nila ang paglilitis na ito. Ngunit hindi. Hindi po. Sapagkat ang usapin ngayon ay patungkol sa isang bagay na pag-aari nilang lahat. Ang kanilang pera, ang kanilang tiwala, ang kanilang karapatan na maningil ng pananagutan mula sa mga pinuno na kanilang pinagkatiwalaan. Kapag ang isang empleyado ay nagkamali ng paggamit ng pera ng kumpanya, siya ay pinagpapaliwanag. Kapag ang isang barangay treasurer hindi maipaliwanag ang nawawalang pondo, siya ay iniimbestigahan. Kapag ang isang principal ay naglustay ng pera ng bayan, kahit 5,000 lang yan, siya ay pinaparusahan. Natural lamang na magtanong ang sambayanan, kung ang ordinaryong Pilipino ay pinapanagot, bakit hindi ang pinakamakapangyarihan na opisyal ng pamahalaan? Ito ang dahilan kung bakit mahalaga ang paglilitis na ito. Hindi upang usigin ang isang tao, hindi upang maghiganti sa kalaban, hindi upang manalo sa politika, kundi upang sagutin ang isang tanong na napakahalaga sa kinabukasan ng ating republika. May saysay pa ba ang pananagutan sa ating bansa? Sapagkat ang kasong ito ay higit at lampas sa sino mang opisyal. Higit at lampas sa anumang partido. Higit at lampas sa alinmang administrasyon. Your Honors, the framers of the Constitution understood that there may come a day when extraordinary power would be entrusted to extraordinary office. They also understood that there may come a day when trust would be broken. And that is why they gave the House of Representatives the power to impeach and the Senate the duty to judge, not to punish political opponents, not to settle political scores, but to protect the republic itself. That is why the Constitution declares public office is a public trust. Ang kapangyarihan ay hindi pag-aari ng sino mang opisyal. Hiram lamang ito sa taong bayan. At ito ang dahilan kung bakit naririto tayo ngayon. Your Honors, the prosecution will present exactly what the Constitution requires. Evidence, hindi chismis, Hindi haka-haka, hindi propaganda, at lalong hindi SOCMED narrative. Evidence, official records, financial documents, government reports, video recording, statements under oath, independent findings of institutions created by law. Mga dokumento na hindi bumoboto. Mga records na walang partido. Mga katotohanan na walang kulay pampolitika. Sa unang tingin, maaring magmukhang magkakahiwalay ang 4 articles of impeachment. Confidential fund, unexplained wealth, bribery and corruption, threat against constitutional order. But these are not 4 separate stories. These are 4 chapters of the same story. Story about power exercised without accountability. Story about public trust betrayed. Story about public office that stopped answering to the public. On the first article of impeachment, the evidence will show that more than 612 million pesos in confidential fund entrusted to the office of the Vice President and the Department of Education were disbursed, transferred, and liquidated under circumstances that cannot withstand scrutiny. 612 million pesos. Hindi ito pera ng gobyerno. Pera ito ng sambayanan. Pera ng manggagawa. Pera ng magsasaka. Pera ng OFW. Pera ng guro. Pera ng bawat Pilipino na nagbabayad ng buwis at nagtitiwala na gagamitin ito ng tama. The evidence will show liquidation reports supported by questionable documents. The evidence will show acknowledgement receipts bearing names government records could not verify. Names that transformed accountability into a mockery. Pananagutan na naging kalokohan. Names that insulted the intelligence of the Filipino people. Mary Grace Piatos, Milky Sikuya, Kokoy Villamin. On the second article of impeachment, the evidence will show financial transactions involving billions of pesos associated with the respondent and her husband. Billions. Hindi milyon, bilyon. At habang milyon-milyong Pilipino ang nagtratrabaho at nag-iipon buong buhay upang magkaroon ng sariling bahay, makapagpaaral ng mga anak, magkaroon ng kaunting seguridad para sa pamilya. Aba, bilyon-bilyong piso ang dumaan sa mga bank accounts na hindi maipaliwanag ng maayos. This article is not about wealth. This is about accountability. This is about explanation. If wealth was lawfully acquired, where is the lawful explanation? If transactions were proper, where is the complete accounting? If numbers truly add up, then why do they refuse to reconcile? On the third article of impeachment, the evidence will show bribery, graft, and corruption through the distribution of cash payments and monetary gifts to officials under the supervision of the respondent. This article is not simply about envelopes. This is about institution. This is about whether loyalty was purchased rather than earned. Government cannot function if loyalty is purchased instead of earned. Kapag nabibili ang katapatan, nawawala ang integridad. At kapag nabibili ang opisyal, nabubudol ang bayan. Perhaps the greatest tragedy is where the conduct allegedly occurred. In the Department of Education. Tama po sa DepEd. the institution entrusted with teaching future generations honesty, responsibility, integrity. On the fourth article of impeachment, the evidence will show culpable violation of the Constitution, high crime, betrayal of public trust through conduct that threatens constitutional order. Among all allegations before this court, none strikes more directly at the heart of constitutional order than this one. Ito na po ang pinakamatindi. And unlike in many cases, which depends upon competing accounts, this evidence comes substantially from the respondents' own recorded public statements. The court will see them. The court will hear them. The court will judge them. Public officials may disagree. We may criticize one another. They may compete fiercely for power. That is democracy. But democracy ends when violence begins. Sa kasaysayan ng ating republika, walang vice presidente na may kaibigan na hitman. Ngayon lang, walang vice presidente na nagpapapatay ng Pangulo. Ngayon lang, walang vice presidente na handang magpapatay para lamang makaupo sa pwesto. Ngayon lang. The Constitution provides many means on how to resolve political conflict. Election, legislation, public debate, judicial review, and even impeachment. But it does not permit threats. It does not permit violence. It does not permit people entrusted with power to place themselves above constitutional restraints. Your Honors, at the center of this case lies a simple question, perhaps the most important to any republic. When the people entrust power to a public official, does the public official remain accountable to the people, or do the people become accountable to the public official? The Constitution's answer is very clear. Power belongs to the people. Public office is merely borrowed, and every borrowed power carries with it the obligation to account for its use. If a barangay treasurer must account for public fund, then so must the Vice President. If an ordinary public servant can be investigated, then so can the highest officials of the government. If ordinary citizen is expected to obey the rules, then surely those who govern them must obey them first. Otherwise, what lessons do we teach our children? That there is law for the powerful and another for everyone else? That accountability exists only for the weak? That public office grants immunity against accountability? Your Honors, this is not the republic envisioned by the Constitution. This is not the republic deserved by the Filipino people. Therefore, the prosecution asks only this: look at the evidence. Listen to the witnesses. Examine the records. Follow the evidence wherever it leads. Judge this case not by politics, not by popularity, not by fear, not by loyalty. Judge this case by the Constitution. Judge this case by the evidence. Years from now, future generations will not remember today's political alliances. They will not remember today's headlines. They will not remember today's slogans. What they will remember is when accountability was tested, the institutions of the Republic stood firm. They will remember only one thing: what this court did when the Constitution called. Future generations will not ask how powerful the respondent was. They will not ask how loud the political debate became. But they will ask one thing: when the Constitution called, did the Republic answer? Your Honors, this is that moment. This is the moment the Constitution anticipated. This is the moment when accountability must mean exactly what it says. This is the moment when public office must truly remain a public trust. This is the moment when the Republic must demonstrate that laws are applied equally to the powerful and the powerless alike. At matapos marinig ang mga saksi, matapos masuri ang mga dokumento, matapos matimbang lahat ng ebidensya, ang prosekusyon ay naniniwala at naninindigan. Isa lamang ang maliwanag na konklusyon: ang tiwalang ipinagkaloob ay nilabag. Ang kapangyarihang ipinahiram ay inabuso. At ang konstitusyon mismo ang humihingi ng pananagutan. Amid the clarity of the mandate of the Constitution, political noise continues. Political squabbles continues. Political division continues. Please, let me conclude. Salus populi est suprema lex. The welfare of the people is the supreme law. Thank you, Your Honor.
The opening remarks of the prosecution through the lead counsel is duly noted. Opening remarks for the respondent. Counsel for respondent has 15 minutes, and we will give you the same latitude we gave counsel for the prosecution for an additional 3 minutes, should you so need it. You may proceed, ma'am.
Thank you, Your Honor. Your Honors, fellow Filipinos, good afternoon. As we begin today the impeachment trial of the Vice President, and in the days ahead, this court will undertake its constitutional task of receiving and weighing the parties' evidence, and ultimately to decide whether these pieces of evidence justify either a judgment of conviction or acquittal, guided only by its members' conscience and their solemn oath to do impartial justice. The present undertaking of this court, therefore, not only carries the weight of the Constitution, but also the imprint of our nation's history, because the Filipino people have shown that they never forget. We, as a nation, never forget. But why is the act of remembering important? What does it matter to our history and to ordinary Filipinos? Because in this trial, the prosecution proposes that we unseat the Vice President elected to office by more than 32 million Filipino people, more than the number of votes cast for the sitting president, and much greater than any of the votes secured by each of the members of the House of Representatives who now are here to prosecute her and seek to undo this people's choice. Sa makatwid, ang malinaw na layunin sa likod ng mga paratang na ito ay ang pagpapatalsik sa isang vice-presidenteng inihalal ng mahigit 32 milyong Pilipino at bunga ng kanilang malayang pagpapasya. Whatever one's political persuasion is, the reality is that the prosecution now comes before this court to remove a vice president chosen by an overwhelming number of the electorate.
You all have heard the prosecution say repeatedly that this is because they seek accountability, that the people have a right to hold their leaders accountable. This is not a matter of debate. Indeed, the people have a right to demand accountability from their leaders. What we have yet to hear from the prosecution, however, is this. When the Constitution declared under Section 1, Article 11, that public office is a public trust and that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives, the Constitution does not only speak to the Vice President. It also demands the same standards from the prosecutors. Being public officers themselves, the public prosecutors and the members of the House of Representatives are also held to the same constitutional standard. And so we must remember what history tells us. This is not the first time that members of the House of Representatives have attempted to remove the Vice President, and in a manner not compliant with the Constitution. In a July 25, 2025 decision, the Supreme Court unanimously declared in Duterte versus House of Representatives, GR numbers 278353 and 278359, that the impeachment proceedings in the House of Representatives were tainted with grave abuse of discretion, rendering the articles of impeachment that the House transmitted last year to the Senate as void ab initio. Early this year, the Supreme Court unanimously denied with finality the House of Representatives' motion for reconsideration of that decision, with a reminder that while impeachment is a powerful democratic process to call out corruption and grave abuse, impeachment can be abused, and that impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them from doing what they were sworn to do. But perhaps the most enduring reminder of the Supreme Court that we must not forget in the entire course of this trial is that, in the words of the court, the rule of law that does justice is our lodestar, and that justice includes accountability. Justice includes fairness. Without fairness, there is abuse. This fairness is what our democracy is all about. It is in light of these reminders that we draw attention to certain fundamental legal principles that we think we must not forget throughout this trial. Mga batayang prinsipyo na dapat nating tandaan sa buong panahon ng paglilitis na ito, anuman ang ating kulay o politika. If we are to be true and honest to our proclaimed values, such as the pursuit of accountability, justice, and integrity in our system of government, then we must remain possessed of an unyielding resolve to ensure that the trial and judgment in this case are done in accordance with the command of the Constitution, the majesty of the law, and the discipline required by the rules. Otherwise, those who stand in sanctimonious judgment of the Vice President will send a clear message that the law can be bent when it suits the convenience of the powerful, and that justice can be sacrificed at the altar of partisan interests. Mahalagang tandaan ang mahigpit na paalala ng ating Korte Suprema. Impeachment is not a purely political proceeding. It is primarily a legal, political, and constitutional mechanism. Ibig sabihin, kailangang naayon sa batas at konstitusyon ang anumang proseso nito. According to the Constitution, it is the Senate that shall have the sole power to try and decide all cases of impeachment. This power is not shared. The Constitution gives no other body, department, tribunal, agency, or a mere committee of any of these institutions the power to try an impeachment case. The House merely initiates, the Senate tries. Yet, we have seen the Committee on Justice conduct what its chairperson, the lead prosecutor in this case, described as a mini trial, which, as we all had witnessed, became a vast fishing expedition of alleged evidence that were not even part of the impeachment complaints under its consideration and which the respondent accused was made to answer. In that mini trial, we saw how the purported pieces of evidence were curated to construct a narrative against the Vice President even before this case reaches trial. The articles of impeachment presented before this court as an exercise of the House's power to initiate impeachment cases are therefore, in sober truth, the product of an impermissible intrusion of clear constitutional boundaries. Over the course of the impeachment trial, the prosecution will attempt to convince this court and the court of public opinion that the allegations in the articles of impeachment are supported by materials they obtained during their mini trial and that evidence exists to sustain a judgment of conviction. They will claim that the notices of suspension and disallowance issued by the COA and the COA decision denying the Vice President's appeal of that disallowance support their accusations, with the release of that decision by the COA conveniently timed and coinciding with the committee hearings. They will claim that the certifications of the PSA confirm their allegation that recipients of the confidential funds do not exist, even though they listed one Mary Grace Piatos in their pre-trial brief as among their witnesses, or that the liquidation of the confidential funds in a span of 11 days was allegedly swift as to invite suspicion. The prosecution will assert that the supposed NBI findings of similar signatures across a number of acknowledgement receipts submitted to the COA are supportive of their conclusion that the disbursements of the confidential funds were irregular. What the prosecution avoided informing the public so far are these: that it was the then Secretary of the Department of Budget and Management, Amena Pangandaman, who issued a memorandum for the President through Executive Secretary Lucas Bersamin on October 18, 2022, recommending the approval of the Office of the Vice President's request for confidential funds. That the Office of the President did in fact approve that recommendation of the DBM through a memorandum from the Executive Secretary dated November 28, 2022, and signed by the former Executive Secretary Lucas Bersamin by order of the President. That on December 13, 2022, the DBM issued a special allotment order number SARO-BMB-C-22-001-2004, signed by former Secretary Amena Pangandaman to cover the request of financial assistance, subsidy, and confidential funds of the OVP that, notwithstanding the impending end of the fiscal year, the confidential funds were nonetheless released to the OVP on December 20, 2022 under this documented approval process. That the COA decision is far from being final, that there is a pending motion for reconsideration of that decision, that, assuming arguendo, the COA denies that MR today, or while this trial is ongoing, as could plausibly happen under the circumstances, the respondent accused still has legal remedies available under the law and rules and can file a petition to question the validity of any forthcoming resolution of the COA on the MR under Rule 64 via petition for certiorari under Rule 65 of the Rules of Court, and more importantly, that nothing in the notice of disallowance or COA decision states any findings of supposed misuse of confidential funds as confirmed by Attorney Gloria Camora when she was asked on this point during the committee hearing on April 14, 2026. Across all other articles, the prosecution will lay a landscape of what it deems to be their evidence in support of their speculations and conclusions. We are not strangers to all these accusations, precisely because this was not the first time these narratives were foisted into the minds of the general public. We have heard the same tales and stories of these accusations since 2024, when the House conducted its Quadcom hearings and most recently the mini trial of its Committee on Justice. But what we must not forget amid all these accusations is the fundamental legal principle that the burden of proof never shifts. The burden of proof never shifts. He who accuses must prove his allegations with evidence that meets not only the degree of proof required, but also meets the evidentiary standards of admissibility, credibility, relevance, materiality, and competence. We therefore should not lose sight of the core principle that the burden of proof is on the prosecution, and unless it discharges that burden, the accused need not even offer evidence on her behalf, and she will be entitled to an acquittal. This is the law then. This is the law now. And the underlying principle for this burden of proof is simple. Under our Constitution, every accused is presumed innocent until proven otherwise. An accused has in her favor the presumption of innocence, which the Bill of Rights guarantees. This also brings to fore the reality that, in the words of the Supreme Court in People versus Pagal, the individual citizen is but a speck of particular molecule vis-a-vis the vast and overwhelming powers of government, and his only guarantee against oppression and tyranny are his fundamental liberties under the Bill of Rights, which shield him in times of need. Sa madaling salita, kinikilala ng ating saligang batas na sa bawat paglilitis, ang isang individual ay nahaharap sa malalim at napakalaking makinarya ng buong Estado. At ang tanging sandigan lamang niya laban sa anumang pang-aabuso ng kapangyarihan ay ang kanyang mga batayang karapatan sa ilalim ng ating konstitusyon. Kaya't mahalagang linawin na sa gitna ng pagtatangkang ikondisyon ang kaisipan ng mamamayang Pilipino at sa gitna ng walang humpay na komentaryo sa mga pampublikong espasyo, wala pang maituturing na anumang ebidensya o alegasyon na napapatunayan ng prosekusyon sa simpleng dahilan na ang bawat ebidensya ay kailangang dumaan muna sa paglilitis at pagsusuri ng korteng may tanging kapangyarihan sa ilalim ng ating saligang batas. Higit sa lahat, ang anumang paglilitis ay kailangang naayon sa itinatakda ng ating batas at konstitusyon at hindi lamang sa kagustuhan ng iilang may hawak ng kapangyarihan. One might ask, why is it important that we must not forget these basic principles? The ruling of the Supreme Court tells us why. The Bill of Rights applies to the entire impeachment process because inasmuch as our court recognizes that impeachment is a political process, it reminds us that it is not a purely political process but a legal and constitutional mechanism. Thus, if we are to uphold the rule of law, serve justice, and invoke the accountability mechanism, then this court and we as a people must guarantee that all efforts to hold our leaders accountable must be done right. This we must not forget. I thank the court and the public for the privilege of your time. May God bless our country.
Opening statement of the counsel for respondent is duly noted and entered into the records. The court will now proceed to dispose of some of the incidents that were brought up during the pre-trial conference, as well as other pending matters and motions. First, on the sequence of the presentation of the articles of impeachment. The pre-trial order stated that the prosecution has a free hand to determine the sequence of the presentation of the articles of impeachment. However, respondent will be similarly accorded the same right insofar as the presentation of their evidence and witnesses in chief is concerned. may we now learn from the public, from the panel of prosecutors rather, what will be the sequence of presentation of the articles of impeachment that they intend to pursue? Attorney Jokno is recognized. You may proceed, sir.
Thank you, Your Honor. The first article we will be presenting will be Article 4 on grave threats. Second will be confidential funds, Article 1. Third, bribery, that is Article 3. And the fourth is unexplained wealth, Your Honors. That's Article 4.
No, 2.
I'm sorry, Article 2. I stand corrected.
So the sequence of presentation shall be Article 4, Article 1, Article 3, and then Article 2.
Yes, that is correct, Your Honor.
So I presume that beginning tomorrow, once we issue the subpoena for your first set of witnesses, you shall begin with Article 4.
Yes, Your Honor.
Again, Chair rules that the respondents have the same and equal privilege of presenting its case as it so desires when it's time to present its evidence in chief shall come. What is the pleasure of the counsel for respondent?
Thank you, Your Honor. May I ask if the prosecution is ready to present its first witness today because the defense is ready today, Your Honor?
Duly noted. We will get to that later.
If
Next
Your
item
Honor,
in the
please.
agenda.
If Your Honor, please.
Yes,
I
Representative
have just
Jokno.
noticed that Your Honor had already directed the counsel for the defense not to propound questions to the prosecution. This is already the second time that she's doing that. She appears to be assuming or arrogating the powers of the court, because as I understand the rules, it's only the court that can propound questions to the counsels.
Your Honor, may I comment?
The lady may comment.
I
Counsel
take
for respondent may
exception to
comment.
that. Yes, Your Honor. I take exception to that manifestation of the good counsel. In fact, the record would show, and if we can run the transcript back, my question was addressed to the presiding officer, Your Honor.
Let us move forward, gentleman and lady. Next item for us to dispense with, the witness disclosure rule. The prosecution proposed a 3-day witness disclosure rule. The respondents proposed a 5-day witness disclosure rule. But I understand the prosecution is amenable to the 5-day witness disclosure rule. Would that be
Yes,
correct,
Your Honor.
Representative Jokno?
We are amenable to the 5-day disclosure rule.
Chair therefore rules that insofar as disclosure to both to either party of a witness to be presented, not mentioned in the pre-trial order and or briefs of the parties shall be for 5 days. This is subject also to the chair's reminder that at the end of every week, that would be a Wednesday while we are on recess, we will ask the party presenting their case in chief to enumerate the witnesses they intend to present for the following week with the corresponding motion for the request of issuance of subpoena to be submitted the day before or on Tuesday, so that we can act on it before the last day of the week so that the subpoena can be properly issued in due course and in due time. So ordered. On the examination of a witness by more than one counsel as propounded or proposed by the prosecution, the rules of the Senate are clear. Article 15 of the Rules on Impeachment states, witnesses shall be examined by one person on behalf of the party producing them and then cross-examined by one person on the other side. Court therefore rules that as a rule, only one person shall present a witness. However, in the exigency of the delivery and administration of justice and under certain exceptions, the court may allow more than one counsel to examine and or propound questions to a witness. To cite an example, just for the sake of the record, if, for example, the panel of prosecutor disagrees with how the counsel for prosecutor is handling the case, the panel of prosecutors or one of them can take over, and that is but proper and should be allowed and will therefore be considered as an exemption to that rule. And other similar exigencies will be allowed in order to afford the orderly administration of justice and of these proceedings. So ordered. Insofar as the BIR box is concerned, what is the pleasure of Insofar as the BIR box is concerned, this box was turned over to the Senate as part of the documents, including the articles of impeachment. However, the court is not yet in custodia lehis of this box, given that there is no lawful order issued by the court for this box to be turned over to the Senate. More so that it is not yet offered in evidence, not even as of yet marked. The chair therefore orders that the BIR box, closed, sealed, and as it is received, be sent back to the BIR, or the Bureau of Internal Revenue, without prejudice to any action that the court may take if a motion will be filed by either party for the issuance of a subpoena, and we shall await action, if any, by the BIR Commissioner should that time come. So ordered. Now, insofar as the subpoena requested by the prosecution for the two NBI agents, may I request the clerk of court to kindly read the motion for the issuance of subpoena ad testificandum.
The prosecution, to the undersigned public prosecutors, respectfully requests the issuance of subpoenas ad testificandum, directing the following witnesses to appear and testify before the Honorable Impeachment Court on July 6, July 7, and July 8, 2026 at 2 p.m., as their testimonies are material, relevant, and necessary to establish the allegations under Article 4 of the Articles of Impeachment, as well as matters necessarily incidental thereto, and for purposes of the identification and authentication of other evidence before the Impeachment Court. Number 1, Attorney Jeremy C. Lotok, Regional Director, National Bureau of Investigation. Number 2, John Mark Kalilong, Senior Agent, National Bureau of Investigation. Respectfully submitted, Quezon City for Pasay City, July 1, 2026.
We are not in receipt of any reservation or objection on the part of the respondent, counsel for respondent rather. However, Chair would like to ask the prosecutors, do you only request for a subpoena ad testificandum or a subpoena duces tecum as well?
If I understand the record, Your Honor, please, it is a subpoena both for ad testificandum and duces tecum.
The motion filed by the prosecutors is only for a subpoena ad testificandum. That's why the chair is clarifying.
Your Honor.
I stand corrected, if Your Honor, please. It's just for ad testificandum.
Counsel for respondent?
If I may, Your Honor, just to set
Please
the record
proceed.
straight, the presiding officer earlier inquired mentioned that the court is not in receipt of any objection from the respondent. But just to set the record straight, the respondent has not received any copy of the request for subpoena being mentioned today, Your Honor. Were we able? What we received, Your Honor, was a manifestation containing the list of the witnesses of the prosecution for July 6, 7, and 8, Your Honor. And so it would be impossible for the defense or the respondent to object or to even comment on a request that we were not served with any copy with.
The two witnesses against whom a subpoena has been requested by the prosecution were mentioned in the pre-trial brief of the prosecution and was not commented on by the respondents in their pre-trial brief. But if you do have any objections now, the court would be more than glad, or reservations, the court would be more than glad to hear it before ruling on the motion for the issuance of a subpoena on these two NBI agents.
At this point, Your Honor, that's fine. We'll just place on record our objections as the testimonial evidence is presented.
Duly noted. Chair hereby orders that the subpoena ad testificandum and duces tecum be issued to the aforementioned two NBI agents contained in the motion filed by the counsel for the prosecutors. Although by nature subpoena is ex parte, we would Chair would instruct the clerk of court to kindly upload all of the filings of all of the parties to the website for the information not only of the senator judges, but also of the parties and their counsels. The chair earlier, counsel for respondent, said that witnesses for the succeeding week shall be manifested in open court on the last day of the trial, in this case by Wednesday, insofar as the next week's trial is concerned. So ordered. Now, insofar as the request for subpoena for bank records and AMLC records, Chair recognizes the Clerk of Court to kindly read and spread into the records the request for the issuance of subpoena, both, I believe, ad testificandum and duces tecum, or just duces tecum, for the aforementioned documents. The Clerk of Court may proceed.
Request for issuance of subpoena duces tecum. The prosecution respectfully requests the issuance of a subpoena duces tecum to the branch manager of the following banks: BPI Julia Vargas Branch, BPI Green Hills EDSA Branch, Philippine Savings Bank Wilson Branch, BDO Unibank Inc. Davao CM Rector Branch, Metrobank Davao Ecoland Branch, BDO Unibank Davao Rizal Branch, Security Bank Bikutan Branch, Land Bank San Pedro Branch, Philippine Savings Bank Davao MADR Branch, requiring him or her or his or her authorized representative to submit to the clerk of the impeachment court on or before 24 June 2026 at 9 a.m. the certified true copies of all records, documents, books, papers, electronic data, communications, and information in the possession, custody, or control of the bank relating to any account, deposit, investment, trust, loan, safety deposit, or other financial transactions maintained, opened, closed, controlled, beneficially owned, or jointly held by Sara Z. Duterte and or Manasseh R. Carpio, whether individually, jointly with each other, jointly with any other person, or through any authorized representative, nominee, attorney-in-fact, or signatory for the period January 1, 2007 to December 31, 2025, including but not limited to: number 1, records identifying account numbers, account types, know your customer documents such as but not limited to customer information forms and signature cards. Number 2, monthly bank statements, average daily balances per calendar year, year-end balances from January 1, 2007 to December 31, 2025. Number 3, all account and transaction records, ledgers, and journals and similar instruments from January 1, 2007 to December 31, 2025. And number 4, all other relevant bank documents. Request for subpoena duces tecum to the Anti-Money Laundering Council, to Honorable Eli M. Remolona Jr., Chairman, AMLC, to Attorney Ronel U. Benaventura, Executive Director, AMLC, requiring him or her or his or her authorized representative to submit to the clerk of the impeachment court on or before 24 June 2026 at 9 a.m. original or certified true copies of the following: number 1, all reports of covered transactions and suspicious transactions filed by banks and all other financial institutions and covered persons required to submit covered transaction reports and suspicious transaction reports to the AMLC involving Sara Duterte Carpio and or Manasseh R. Carpio covering the period of 2006 to 2025. Number 2, any and all investigation reports or related reports or documents prepared by the AMLC over transactions or suspicious transactions. 3, electronic copies including Microsoft Excel files, database extracts, or machine-readable formats of AMLC, CTRs, and STRs for the period 2007 to 2025 involving Sara Duterte Carpio and or Manasseh R. Carpio. Respectfully submitted, Quezon City for Pasay City, June 18, 2026.
Your Honor, may I comment?
If Your Honor, please, before the defense makes a comment, just to obviate the proceedings and to facilitate the hearing today, if I may.
The chair has not recognized anyone yet.
May I be recognized, Your Honor?
Yes, the counsel for prosecutor.
If Your Honor, please. The subpoena request that was just read by the clerk of court pertains to a request that the prosecution filed in early June where we had requested that the documents specified be brought to the Honorable Court on June 24. Since that date has passed and no subpoena has been issued, we had refiled just this afternoon a subpoena reiterating the same requests. And in the interest of justice and to allow the defense to comment or if they want object to the request that we filed this afternoon, perhaps if I may suggest, if Your Honor please, that we provide the copy to the defense, give them a period of time to submit their opposition or objection, and as well the same period of time to the prosecution to reply before the Honorable Court rules on this
Counsel,
request.
Is the motion for subpoena ducis tecum and/or ad testificandum that you filed today exactly the same as what you filed before?
No, Your Honor. It contains the same documents that we had requested earlier, but there were some additional documents that were also mentioned in the request we filed this afternoon.
So you asked for additional documents and
Yes,
information?
Your Honor.
What does counsel for respondent say?
Your Honor, before I give my comment on the request for subpoena, I thank the good counsel for offering to provide us a copy of the request for subpoena, but we would also ask that we be provided with the June 2026 copies of the request for subpoena as well as the new one that the counsel mentioned today. But just for the record, it would seem to me that the request for subpoena covers documents involving years from 2006 up to 2025. And again, just for the record, this would seem to violate the Duterte versus HOR ruling, which very clearly states that the impeachment must be only for those acts or omissions within the impeachable years and terms and office of the official. But nonetheless, Your Honor, just so we're able to fully ventilate whatever objections or comments that we may have on this request, and considering that for today and in the disclosure made by the prosecution, they will begin with Article 4, and all these documents seem to pertain to Article 2, then we will ask for 10 days to file our comment on this request for subpoena, Your Honor. From today, Your
Chair
Honor.
hereby directs that all motions for the issuance of subpoena ad testificandum, subpoena ducis tecum filed by either parties be furnished to opposing party and/or counsel before filing it before this court in order to provide full disclosure and fairness. But instead of 5 days, counsel, Chair is giving both parties 5 days to submit their respective memoranda and/or position insofar as it is concerned. We will afford the parties time to argue their position before the court so that the senator judges can hear your position in addition to your extended written memoranda insofar as this crucial issue of issuance of a subpoena ducis tecum ad testificandum on certain bank records and AMLC records, which the chair will schedule, giving ample notice to the parties in due time. Is that okay with both sides?
Just for clarity, Your Honor.
Yes, counsel for respondent.
May I ask that the period, if the period for the parties to submit or the respondent to submit its comment, her comment on the request for subpoena would be 5 days from today, Your Honor?
From today, but you can submit it on Monday since it lands on a Saturday.
Second, Your Honor, the presiding officer mentioned that we also must submit a memorandum or position paper on this, Your Honor?
If you so desire, or you simply can argue it in open court,
okay,
but you may want to submit an extended written memorandum on the matter for the easy reading of the senator judges pertaining to this issue.
Last, Your Honor, will the court also schedule an oral argument on the respective positions of the parties?
Yes, Chair will do that.
Thank you, Your Honor. And this would not be on Monday, Your Honor.
No, that will not be on Monday.
Thank you, Your Honor.
If Your Honor,
Counsel
please.
for prosecutor?
Yes. May I be allowed to make a counter manifestation, just a brief one with respect to the statement of the defense counsel regarding the application of the case of Duterte versus House of Representatives.
The gentleman may proceed briefly.
Your Honor, the decision and the resolution of the Supreme Court in that case did not say that any preterm evidence is inadmissible. There is no statement like that at all in the entire decision and the resolution. What the Supreme Court said, and I quote, was very simple. The basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. All of the articles in this particular case pertain to impeachable acts committed by the Vice President during her term as an impeachable officer, including unexplained wealth. If I may just be allowed 1 minute, Your Honor, to explain that. The
1 minute.
Unexplained wealth, Your Honor, that is amassed prior to the term of a Vice President is relevant and material to her being an impeachable officer, because wealth of the magnitude of millions or billions ay meron pa rin pong pakinabang po yan ang Vice President kahit hanggang ngayon. It's very clear that when a local government official, for example, who later becomes a national official, amasses hundreds of millions, if not billions of pesos, then that benefit continues today. Second, if Your Honor, please, integrity, hindi po pwedeng biyakin po yan na kesa dati ay hindi po ganon at ngayon may integridad. It's very clear that integrity is a continuing requirement of fitness for office. Thank you, Your Honor.
Duly noted and entered into the records.
May I respond? Just very briefly, Your Honor.
Counsel for Respondent.
Much time of the impeachment court.
As a rejoinder to the statements and manifestation of Representative Jogna, briefly.
Thank you, Your Honor.
You may proceed.
I think the good counsel has already stated precisely the reason for our position. We maintain our belief that the Duterte versus HOR ruling precludes any of these trawling incursion, again, on private records of so many individuals and so many entities when nothing in the articles of impeachment point to any specific allegations as to the relevancy of all these documents, Your Honor. But nonetheless, we will include all our position and as well as our objections on the request made today with respect to these documents, and what it would seem to the defense would be another 2.0 version of a fishing expedition. May I also, Your Honor, just to clarify also the period given to us to comment on the request for subpoena, may we ask that the 5-day period run from our receipt of the copies of the documents, Your Honor.
We will make sure that the Counsel for Respondent will get that today.
Thank you, Your Honor.
The comments of both counsels of the parties are duly noted and entered into the records. Chair would like to apologize to Senator Cayetano, who has been waiting for quite some time. Thank you for your patience and indulgence. Senator Cayetano is recognized. What is your pleasure,
Presiding Senator Judge. Since we already stated as a court that we will take literally Section 3, subparagraph 6 of Article 11 of the 1987 Constitution, that no person shall be convicted without the concurrence of 2/3 of all members of the Senate, may I ask the members of this court, through the presiding justice, to consider, not today, I have a proposal, but not today, but to consider communication with the Sandigan Bayan for the attendance of Senator Dante Marcoleta and Senator Jinggoy Estrada, considering that the presiding officer may correct me if I'm wrong, but if we get to Section 21, as discussed a while ago by the defense, the prosecution and defense, and we do not know what will happen. Their case may be dismissed. They can be out on bail. So we want them to be able to participate and observe the witnesses as senator judges here. I do know that Senator Jinggoy is under suspension, but there's an argument to be made that the impeachment court is sui generis. In ordinary committee hearings, we do coordinate with courts to ask that persons under their custody be delivered to the Senate or the House of Representatives under certain conditions. So I'd like to formally ask, Mr. President, that this court consider that. I will submit whether you'd rather have a caucus or a in-camera discussion, or if you want us all to submit our legal opinion. I wouldn't also mind the prosecution and defense weighing in, but considering that if they do not attend and they are here, sorry, Mr. President, considering that if they do not attend at all and cannot vote, their vote will be equal to a acquittal. And as we said from the start, we want a fair and we want justice, we want a fair impeachment trial. Sinabi ng prosecution na sana tignan yung ebidensya, pakinggan mga witnesses. So kahit gawin to ni Senator Marcoleta at kahit gawin to ni Senator Jinggoy, and of course this is my personal opinion that may politika sa pagpapakulong sa kanila. That's my personal view. Allowing them to attend here might add to the integrity of the proceeding and actually make things easier when the time comes to render a verdict. So may I submit that to the court and to our colleagues for discussion at the proper time, Mr. President.
The chair notes the comments and requests of Senator Judge Cayetano and will consult the senator judges regarding this matter and shall coordinate with his office with respect to his requests pertaining to Senators Jinggoy Estrada and Senator Marcoleta, including whether or not we will enlist the comment on and position of the parties to this case. So ordered. Senator Tulfo? What is the pleasure of Senator Judge Tulfo? Rafi?
Mr. Presiding Officer, as far as I'm concerned, I would allow siguro mag-monitor yung mga si Senator Jinggoy, Senator Marcoleta. They will be allowed na kahit man lang yung sa TV monitor. Para sa akin, I do agree with what Senator Alan Peter Cayetano was suggesting. Thank you, Mr. Presiding Officer.
The point of Senator Judge Rafi Tulfo is well taken by the chair. Any others? If there are none, Presiding Officer would now like to deal with an administrative matter before we adjourn for this afternoon. On the matter of providing public access to case records, yes, Senator Judge Marcos, what is your pleasure, ma'am?
Yes, Presiding Officer, may I request an update? As I recall, during the pretrial conference, there was disagreement on how to go about the markings on the various documents, and among the thousands of pages that we have received in evidence for the trial, it apparently was resolved that the counsels would place their initials on the evidence. Is that correct? Is that still what stands today? And each party would take their respective evidence or files and present the same during the trial to guarantee that the same evidence would be presented. Is that correct?
That is correct, with the exception of some, I think, documents that where the original was not presented, which is being corrected, I think, by the parties as we speak.
Are we, in fact, in receipt as judges of all these thousands of pages? Dahil ako, simple lang hinahanap ko yung affidavit of investigation, yung dalawang NBI na unang testigo na sana haharap ngayon, nakita ko sa libu-libong pahina na sinubmit, mali-mali ang pagka-annex ng AOI, hindi ko talaga mahanap. Tapos, ang sabi doon, Annex G. Pero nung kinalkal ko yung Annex G, hindi naman affidavit yun, kundi disbursement voucher or something like that. Kaya hindi ko alam kung nag-provide ba talaga ang clerk ng Senate ng records as marked during pre-trial at kung pinal na talaga ito at pag-aaralan natin.
At this point in time, Your Honor, documentary evidence as of yet has not been formally offered and therefore has not been turned over to the court. Neither has it as of yet been identified by a witness to authenticate the same and to be allowed admission into the records of this court. That time will come once the prosecution presents their witness and identifies the piece of evidence. That will be the proper time, perhaps, that the good Senator Judge can ask for a copy because the lady might want to ask questions of the witness should that time come for the witness to testify as to the document marked previously erroneously or rightfully by either party.
Yes, precisely. Thank you very much, Presiding Officer. We wish to prepare for the three first witnesses, and we're unable to access any of their affidavits or other documents. Thank you.
Duly noted and entered the records. What is the pleasure of Senator Judge Padilla?
Ginoong tagapamahalang hukom, gusto ko lamang pong sundan yung sinabi ni Senator Judge Alan Peter Cayetano at magpasalamat po kay Senator Judge Raffy Tulfo. Gusto ko lamang pong linawin na ang hinihingi po namin kung hindi man makapag-participate dahil sinasabi nga po ay ipinagbabawal silang makapag-participate at bumoto si Senator Jinggoy Estrada at Senator Judge Marcoleta. Ang hinihingi po namin ay makapunta po sila dito bilang observer. Hindi lang po basta monitor. Yun lamang po. Maraming salamat.
Noted, at the proper time we shall discuss this matter and settle it as a court or in caucus. There being no other Senator Judge who wishes to make a manifestation, comment, and/or motion, Chair would now like to dispose of an administrative matter. Consistent with Article 2, Section 28 of the Constitution on the policy of public disclosure in matters involving public interest and to give life to the directive under the rules to open the impeachment proceedings to the public, the court hereby directs the clerk of court to create the necessary internet web pages to allow the electronic records of impeachment to be made accessible to the public through the Senate website, whereby all pleadings, memoranda, motions filed by the party shall be uploaded, including the journal of the proceedings after it shall have been approved by the impeachment court. Yun lang po siguro yung madedelay ng konti dahil kailangan aprubahan muna ng impeachment court yung journal bago po namin ma-upload sa website. Yes, what is the pleasure of Senator Judge Bam Aquino?
Yes, Mr. President, on this note, firstly, we'd like to second and congratulate this move of the impeachment court to make all of the evidence available to the public. May we know in how many days will the clerk of court make this evidence available to the public, Mr. President?
They've started, but they have not completed it yet. As Senator Judge Marco said, the documents are voluminous. I think it covers until 9Q, if I'm not mistaken, initially, when it was marked. About more than 10,000 documents.
Mr. President, of course, in the same way, if this is made available to the public 6 months from now or 1 year from now, that defeats the purpose of having this made public.
No, that will not happen.
Yes, may we get a commitment from the clerk of court as to the delay by which presented evidence is made public, Mr. President?
No. Let me clarify, Your Honor. I believe the articles of impeachment as well as its annexes have been uploaded. The answer as well as its annexes have been uploaded. And most of the exhibits that were marked, not all, are annexes of either the impeachment complaint and or the answer. Can the chair give you an update before the week is over as to a realistic timetable to upload in real time already? Again, except for the journal, which we need to approve. So we cannot upload the Wednesday transcript or journal until we meet again on Monday and approve the journal of Wednesday. So that would be the only delay, if at all, in uploading it. That should be the only delay.
So if I take it correctly, Mr. President, the clerk of court will endeavor to upload all of the presented evidence in real time at the soonest possible time, except for the journal, which needs approval of the body.
That is correct, Your Honor.
Thank you, Mr. President.
Senator Judge Cayetano Allen.
Presiding Senator Judge, just a clarification. No? So no problem with complete transparency with any public records. But when we talk about evidence, precisely that's why we want a fair trial, due process. There's a process wherein the prosecution shall present evidence, then they will offer it. And then if there's a question as to the relevance or if it is prohibited, for example, if a evidence presented is a fruit of the poisonous tree, will we upload that? We haven't decided yet here whether we will accept it as evidence or not. So let me tell you first which ones, personally, I don't have a problem with. Don't have a problem with the public records in general being completely transparent. I have no problem with senator judges given time to review everything, and I assume we're all trained to consider only the evidence that is later on admitted, offered and admitted. So my problem is that, for example, no, if someone offers now, between now and the trial, wiretapped recordings, do we upload that when we have not made a ruling yet on that? So I just want to be clarified on that.
The chair will clarify. As the chair said earlier, only the pleadings, motions, and memoranda filed by the parties, and insofar as the exhibits marked are concerned, only those attached as annexes to either the articles of impeachment and/or the answer to the impeachment complaint. Insofar as documentary evidence is concerned, it will only be admitted, and if at all admitted by the court and published, once formal offer has been made. Until such time, we will not publish any documentary evidence even after being identified by a witness, because it is the formal offer that will determine its admission by the court after the
Same
party
thing,
rests.
just to clarify, same with if we do issue a subpoena, duces tecum.
The subject matter of the subpoena will not be published, but the motion for the issuance of a subpoena
Thank you.
will.
Thank you for that clarification.
Thank you, Your Honor. Senator Judge Erwin Tulfo is recognized. What is your pleasure, sir?
Thank you, Mr. President. Thank you, Mr. Presiding Officer. Just want to be clarified. I need a clarification, Mr. Presiding Officer, with regards to this Anti-Money Laundering Council documents or pieces of evidence that will be submitted here. Will it be okay if we tackle this in public, or shall we tackle evidence from the AMLAC during an executive session? I believe this is under the bank secrecy law, or we can tackle it because this is an impeachment court, Mr. Presiding Officer.
What we will debate upon, if at all, on the scheduled date to be set by the chair is a debate on whether or not to issue the subpoena duces tecum ad testificandum in relation to AMLC records, not the actual records yet. Once it is granted by the court and is issued, it will have to be presented by the parties. We cannot tackle and discuss it in executive session, because anything and everything discussed in executive session cannot be revealed into the public and used by this court. Secondly, it can only be, if at all, revealed by a unanimous vote or consent by all the senator judges, which effectively hog ties that piece of evidence if we discuss and talk about it only in executive session. Whether or not it is to be made public, whether or not it can be legally obtained, will be decided by this court after hearing the oral arguments of the parties.
Thank you for that clarification, Mr. Presiding Officer.
What is the pleasure of Senator Judge Villanueva?
Yes, Mr. President. Considering that we have been tackling and asking of pieces of evidence, I think there's a lot of questions with regard to the mahiwagang BIR box, Mr. President. Yung clarification lang po, where is it now and when are we going to transfer it to the Bureau of Internal Revenue?
It is with the Clerk of Court in the Office of the Secretary General as instructed by the Chair. It should be sent back to the BIR by tomorrow morning in the condition that it was received, meaning sealed.
The same. Thank you, Mr. President.
Any other manifestations or motions on the part of the Senator Judges? Senator Judge Ontiveros is recognized. What is your pleasure, ma'am?
Salamat po, Mr. Presiding Officer. Just to make a brief statement in support of the ruling recently proclaimed by the Presiding Officer on executive sessions. Thank you, if I may,
Noted.
Mr. Presiding
And
Officer.
records.
And just to add a little bit of that,
Lady, may
Mr.
proceed.
Presiding Officer, thank you. The executive session is only for Congress acting in its usual legislative functions, and impeachment trials do not contemplate executive session. So I join with the Presiding Officer in the call that he made, which I believe is the default also of this impeachment trial court for transparency as a general rule and as a default. Salamat po, Mr. Presiding Officer.
Thank you, Senator Judge Ontiveros. Before the court adjourns, Chair directs the Clerk of Court to kindly make sure that the subpoena for the two NBI agents will be issued this afternoon and duly received, and entrusts it to the Counsel for Prosecutors to make sure of the attendance of their two witnesses tomorrow. Likewise, the Chair reminds the Clerk of Court to furnish, right after we adjourn, counsel for respondents with a copy of the requests for the issuance of subpoena thus far submitted and filed with the Office of the Clerk of Court. So ordered. There being no other business to discuss, the trial is hereby adjourned until 2 p.m. of Tuesday, tomorrow, July 7, 2026.
You're watching Rappler's special coverage of the Duterte impeachment trial. First, we say thank you to Attorney John Molo, Professor of Law at the University of the Philippines, who joined us at the start of the trial. Now, I'm happy to say we are joined by the Executive Editor of Rappler herself, Glenda Gloria.
Hi, John.
First, a quick recap. The trial proper finally started at 3:31 p.m. and then opening statements were heard from the Chief Counsel. But for the first 90 minutes, the minority made an issue of what they alleged to be a constitutional problem, the election of a presiding officer other than the Senate President. What do you think is the minority strategy behind this?
Well, I'm thinking of maybe it's a two-pronged strategy, John.
Mm-hmm.
In the first place, I expected these fireworks.
Mm-hmm.
It's not going to be a smooth impeachment trial.
Mm-hmm.
From day one, they set the tone for it. More fireworks should be expected in the coming days.
Mm-hmm.
The strategy precisely is to delay,
Okay.
to confuse, to muddle at every point, at every chance. But pangalawa, syempre may konteksto din, because you have to remember, Jesus Cordero was the critical vote that turned the Senate leadership around and made Gatchalian Senate President. And therefore, I think the subtext of the Cayetano siblings repartee is that, well, that was the deal, that you made that jump. You jumped to the other side for you to be Senate. So the strategy is really just to sow intrigue, cast doubt on the capacity of the majority to maybe understand. And then there was also a hint of ilang bang abogado dyan? Because obviously the majority only has 2 lawyers, right? That's Cheese and Kiko Pangilinan. And so, yun, ganon. It's really just also playing to what the public, the Duterte public would want to hear.
So aside from Cheese being the crucial vote, what have they against Cheese as presiding officer? I mean, he was the presiding officer of last year, which effectively stopped the impeachment trial then.
I guess for practical reasons as well, they probably would prefer an inexperienced Gatchalian to preside over the trial. You have to remember, Cheese Escudero was also a senator judge at the Corona trial.
Okay.
The Cayetano siblings were senator judges at the Corona trial in 2012. And therefore, they know for a fact that the Cheese can really just maybe navigate this in a more experienced manner. And therefore, they probably I mean, just looking at it very, very, not to diminish the Senate President's capacity and capability, because he has one, has shown his skills as a senator, but this one is a different ballgame.
Okay, now let's go to the opening statement. So the first one from Congresswoman Luistro, which I think ran for 18 minutes, which I understand is the exact length of a TEDx talk. Your reaction to her opening statement?
Yeah, I think he touched all the correct points, which is really a public narrative.
Okay.
Why does this trial matter to you? It's not. This is not about politics. This is about really the voter who elected the vice president and therefore deserves accountability and transparency. Tapos may mga quotable quotes siya, diba? Yung ang mga dokumento na i-represent namin ay hindi bumoboto, walang partido. Tapos yung meron bang vice president na may kaibigan na hitman, diba? So these are really, like, it's a public narrative. Parang kumbaga nag-aral talaga si Luistro ng public narrative, You throw it back to the public. Why does this trial matter to you? And he cited the student, he cited the ordinary employee who'd be punished, etc., etc. And then, di ba yung closing niya is, people will, the future generations, this generation will forget a lot of things, but not how this institution made it stand vis-a-vis the Constitution.
Yeah. She spoke mostly in Filipino. So parang kita mo na talaga who the real audience was. No? In contrast, si Attorney Sheila Sison spoke mostly in English. Meron din siya konting Filipino, especially towards the end. Can we say that she was addressing a different audience, not the public at large?
Yes, because you know why? The pro-Duterte senators will take care of the Duterte public. Okay. I think. I think that I mean, if I were the defense, I'd strategize it that way, right? You have enough, Cayetanos and whatnot to talk to the public. But this one is really more, di ba yung umikot dun sa. But it also caters to two things, because she pointed out, she was elected by the biggest number of votes.
That's right,
in modern, which ironically, Cheese Escudero also cited in his opening remarks. So parang, okay, so there's that. And then he also said that, okay, this is a mandate, and then this is politicized. And then he cites the Supreme Court decision, which is really, it caters both to the legal, I guess, sector, but on the other hand, also in a way public, na-simplify niya, na-crystallize niya, na the issue, and then he laid it on the president. I was surprised that he cited a very specific document, which was signed by the former executive secretary. What was she trying to say? She's trying to say, if the vice president is on trial here, so should be the president, because after all, he signed.
The former budget secretary, Mena Pangandaman, and the former executive secretary, they're in the list of witnesses, right? Yeah. And from the very start.
Sabi pa niya, kung, if you demand accountability and transparency from Vice President, the prosecutor should, So ang hint niya doon is that, well, kayo ba? Diba? He who has not sinned cast the first.
John Molo's not here anymore.
Yeah.
We're not lawyers, but we've covered a lot of stories that are law adjacent. I wanted to ask, my first impression of the opening statement of the respondents' counsel was they weren't really hitting the right notes as far as the legal arguments are concerned. As you noted, she argued from popularity. Like, she argued from political persecution. She argued from the past, pointing to the Supreme Court decision, which was about the previous impeachment attempt, right? So maybe for the first 10 minutes or so of her speech, she was making these arguments, which I thought, okay, but they're not really answering the legal points. My question is, do you think in the end she was able to recover and was actually able to address the legal
I don't think she
arguments?
intended that. You know what struck me when she said this? The accused need not even offer evidence on her behalf. And even without offering evidence on her behalf, she would still be entitled to an acquittal. So that's really, I think, yun yung play nila na maybe the evidence they know what the prosecution will present as an evidence, but they'll go back to that narrative. That is this political persecution, that this is the House of Representatives precisely doing it twice, which is also, they're saying, it reinforces the political motivation angle.
Yeah. Maybe we'll have time later to go back to the opening statements kasi marami nga quotable quotes. But the presiding officer, Senator Chis Escudero, also made important decisions as far as 3 threshold questions are concerned. So the first one is, what does it take to convict? So he said 16 talaga. Did that surprise you?
No. Coming from this senator, no. Did not.
Do you think that was the price the new majority paid? They say, okay, you can join us. I mean, we become the new majority, but okay.
I think this will unravel. So we don't know, right? I mean, I don't want to prejudge the presiding officer. He has his own, but ultimately, I think this is also like the unraveling of the presiding officer, diba? And I mean, you can't be faulted if your prosecution or defense to be always watching him and say, oh my gosh, did he make the decision in favor of the defense this time? And I mean, diba, the first motion of the prosecution kanina was immediately denied by him. But that's technical. I mean, that's parang administrative, which is fine. I remember in the Corona trial, day 1 also, the presiding officer ruled much in favor of the prosecution panel at that point. So, ano lang. Minsan, you can't avoid that magbibilangan kayo. Who won day 1, who won day 2, who won day 3.
Yeah, and another threshold question that he resolved was, what is the quantum of proof? Tapos, of course, it's in general terms. Pero sabi niya, my takeaway is that his formula is conscience plus.
Yes.
Like, what you really think, but also take a look at the evidence.
Yeah.
Again, is that playing to the middle? Is that?
Yeah, playing to the middle. Fair enough. I mean, were you surprised, man?
I was actually surprised. Well, what I'm reconsidering now is how he himself would vote. I'm trying to compare it with his conduct last year.
Last year, which is, diba?
Yeah, I mean, he acted the same way in a sense that, like, he obviously knew the procedure, and of course he had the rule book in his hand, literally. So he was able to make quick decisions. So again, not like the inexperienced Win Gatchalian would have conducted himself. So that kind of demeanor was there. But I'm still wondering, what does this all mean? It occurred to me that maybe the new majority, I don't know, is the new majority resigned to the fact that they don't have the votes to to convict? So let's just go on with the show.
Because 16 votes is formidable. That's a tough climb for the prosecution.
Yeah, and also in one of his many interventions, Senator Alan Peter Cayetano asked the court to ask for permission to ask the Sandigan Bayan to have Marcoleta, Senator Marcoleta and Senator Estrada at least join remotely, and then Senator Raffy Tulfo, who is part of the new majority, said, I have no objections. You can have a TV monitor. What do you think of that?
Yeah, imagine if the two were allowed, right? Then that really, so it's not just a matter of 2/3, but yeah, they will be able to, go out of prison, go to the Senate if that was the ask. And that's where, again, that's the presiding officer. That's why critical talaga eh. I mean, how the presiding officer would balance both interests, but also would project neutrality, because that's what, he said in the opening statement. But let's see.
What else struck you about the first day of the trial?
Aside from the Cayetano siblings, it's not that it surprised me, because they've been doing this since the Senate chaos of a few months ago. But you know what line will they not cross in terms of just Pia Cayetano raising an important matter such as toilet breaks and water breaks, parang ano yan, World Cup hydration breaks. So,
which itself is controversial.
Yes. So there's that. But also,
so they've been the most active, actually, right? The two siblings.
I find it. I'm not sure about the framing of the Senate president seated beside
That actually reminds us of the Estrada impeachment trial, right? When Senate President Nene Pimentel sat beside Chief Justice Hilario David. It didn't strike you, right?
Well, Erap was the president. Maybe because of the context. It's a different context. This one, that there were really negotiations that went into whatever setup we have now in terms of the presiding officer and the Senate president. It's just ano lang.
Yeah, it's a little off also. But at the same time, like you, I also thought maybe it's the product of negotiation. And maybe some people in the new majority said, okay, he can be presiding officer because he's a lawyer. But you can't step down. The Senate president can't step down. You have to share the podium with him. Okay.
From discussing its affirmative defenses or raising evidentiary objections during the trial proper when the relevant questions become ripe for resolution. The trial was adjourned and will resume tomorrow at July 7, 2026 at 2 p.m.
On screen right now, we are seeing and hearing Reggie Tonggol, the impeachment court's spokesperson.
To enter the courtroom in a sequence, or anytime na pwede silang pumasok, ay pwede silang pumasok kahit hindi sabay-sabay, hindi magkakasunod?
Yes. The only requirement po para sa mga senator judges is kapag po mag-roll call so that they can note their attendance na nandun po sila for the existence of the call. Other than that po, they can enter and exit the plenary just like in any plenary session. Actually, that will have to be taken up according to the presiding officer during the plenary session, and I think yun yung mga pag-uusapan ng ating mga senador in either executive session or a caucus, so they will know how to deal with the matter when they raise the senator Cayetano. Hindi na po. Kailangan lang po nilang pag-usapan will they send a letter to the Sandigang Bayan o meron po bang resolution ng Senate regarding that. So yun yung hindi pa klaro kung ano yung course of action na pwedeng gawin para pag-usap formally sa Sandigang.
Pero sir, kailangan plenary session, kailangan mag-resume muna or hindi na?
Alin po?
Yung kailangan mag-resume po muna.
Yung po yung hindi pa sigurado kasi syempre, lagi niyo pong iisipin ang bawat akto po ng branches of government ay magiging opisyal lamang during plenary session, if they are acting as a legislative body, at kapag korte naman po during the session ng impeachment court. So yung po yung mga pag-uusapan nila how they can navigate the matter regarding dun sa bringing up these matters.
The clarification, will you take plenary session as legislative or
At legislative. Kaya hindi kanina nag-rule yung presiding officer kasi it is a matter outside of the purview of the impeachment court.
the clarification, will it be accurate to say hindi ma-actionan yung motion ni Senator Peter Cayetano hanggat hindi na-refer yung session ng
Hindi pa po yan sigurado kung ano yung action. Kasi yun nga po, as I know, meron pong moves po na may liham na pinapakalat po para po magsulat yung ating mga senador doon sa Sandigang Bayan. However, some senators feel na hindi po dapat ganun yung proseso na gawin na ordinary liham. So, they have to settle it amongst themselves kasi we cannot presume or assume kung ano po yung gusto nila. Siguro majority po kung ano yung gusto ng majority, kung pipirma sila doon o hindi, o ihintayin na plenary session, sila po muna ang magbabanggaan ng opinion tungkol dyan. So ngayon po, kung hindi tayo makapagbigay ng opinion kung ano yung dapat o hindi dapat, kasi either way, pwede nilang gawin. Because when it comes to the impeachment trial po, they are equals. May division lamang po ng labor. So, kaya po, we do not want to degrade the office of the Senate President para bumaba po doon sa katulad ng sa upuan ng mga senator judges. So, kaya po, minarapat na parang kapareho lang rin po nung nangyari nung impeachment ni President Estrada, na nakaupo po yung presiding officer, which is the Chief Justice, at katabi niya po yung Senate President, at nandun po dahil po co-equal po sila on that matter. Tama po. Apo. Marami pong basehan po yan. No? Unang-una yung mga previous impeachments po. Hindi na po binasa yung articles of impeachment. Kahit yung naalala nyo rin po yung last year, hindi rin po. Dahil kinukonsidera na po ng trial court ang pag-file ng answer bilang voluntary appearance doon sa respondent. So, kaya po, immaterial na po yung physical o yung actual na pagpunta po ng Vice Presidente dahil nag-file na po sila ng answer. At nandun din po yung mga abogado ng respondent para rin po mag-enter ng appearance in her behalf, katulad po ng sinabi ni Attorney Season kanina. So, in ordinary trial courts po, ginagawa rin po yung wini-waive po yung pagbabasa ng sakdal o yung kaso, at pwede pong mag-enter na lang po ng plea. However, dito po kasi hindi po criminal case to, so sui generis to, alam niyo naman, so hindi na po kailangan mag-enter ng plea ng ganong kapormal na katulad nire-request po ng prosecution. Kaya po kinonsidera na ng korte na sufficient na po ang pag-attend at saka po pagpa-file ng answer bilang voluntary appearance ng respondent. Tama po. Cannot be compelled to attend, one, because meron po siyang right against self-incrimination under the Constitution. Hindi rin po siya kinakailangang pumunta naman kasi wala namang pangangailangan sa pagpunta niya dahil nare-representa na po siya ng kanyang mga abogado. At yung depensa niya ay nare-representa na rin ng answer niya po na final.
Unless voluntary she would come.
Yeah, it's up to her po. Wala pong magagawa ang sino man para pilitin siyang pumunta.
Sabi niyo po, when it comes to impeachment trial, equals yung presiding officer and Senate President.
Actually po, yung Senate President bilang legislative head po ng Senado at yung presiding officer po na elected bilang head po naman ng impeachment trial. Alam niyo naman po, impeachment court rather. Alam niyo naman po na ang kapag sa gantong mga proseso o na nangyayari o proceedings, dual hats po ang ginagawa ng ating Senado bilang legislatibo at saka bilang trial court po. So, yun po yung simbolismo ng pag-upo ng dalawang tao po doon sa taas po. Actually po, napag-usapan na rin po kanina at medyo mahaba-haba ang debate dyan. Meron naman pong basihan yung chair, yung presiding officer, pati po yung mga majority of the senators, nabanggit na rin po ni Senator Kiko Pangilinan yan, na ipinasok na rin sa records po ng impeachment court yung mga kaso ng Umali versus JBC at Chavez versus JBC na nagsasaad na kapag malinaw po ang konstitusyon at malinaw po yung konstitusyon na hindi pinagbabawal po ang pag-elect ng presiding officer in impeachment trial sa Article 11, Section 8 po, Section 3, Number 8, at dahil nagpasa rin po ang Senado ng kanilang rules sa pag-amenda ng Resolution 39, yun po ang naging legal na basehan para valido po ang pag-elect at pag-upo ni Presiding Officer Chis Escudero bilang head po ng impeachment court. I think yung sa correction, ibig sabihin, kailangan kong umamin na may pagkakamali sa last year. Wala pong pagkakamali sa last year. When you're talking about the issues regarding sa pag-file po ng articles of impeachment, I think the respondent Vice President also filed her affirmative defenses, yung violation din po ng one-year bar rule, ililagay niya po sa answer niya. So I think pareho rin po yun sa last year na sagot niya doon sa articles of impeachment. So on that matter po, yung sa affirmative defenses, the presiding officer and the court itself will have to deal with the matter kapag ni-raise na po ng depensa yung mga affirmative defenses na yon during the course of the trial.
Standby. So that is the spokesperson of the impeachment court, Reggie Tongol. In a bit, we will be listening to the spokesperson of the defense, himself one of the defense counsel, Michael Poa. But let's go back to our discussion with our executive editor, Glenda Gloria. We were talking about what struck you in this first 3 hours of the first day of the impeachment trial. We were talking about the role, the high-profile role of the Cayetano siblings. I don't know if you have reservations about Chis Escudero being presiding officer, but how would you rate his performance as presiding officer today?
Well, obviously he showed experience. His the fact that he's a veteran, he knows processes, he knows rules of court. But I think, John, to be very, very frank, the biggest decision today of Chis was the 16 votes.
Yeah.
It's really, because if you remember, the prosecution panel from weeks ago has been saying that, that's not our count. And you have 2 senators already in jail. And some would argue that, well, that's precisely the reason they probably were arrested, to reduce the number. But, that's a big decision today. I think that's the biggest decision today, is that there are 16 votes. needed to convict the Vice President. And if you look at the numbers, I've done my numbers since last year. It would be really a tough climb.
Very difficult to get to
Difficult
16,
to get to
right?
16.
Just for the record, the third threshold question that he addressed was whether rules should be strictly or liberally applied. So he made those three quick decisions, right?
Yes.
But I agree with you. The 2/3 just seems to cut off the legs of.
And now I wonder, sorry, because the new majority held a Senate caucus before this, before 2 p.m. So were the senator judges in the majority aware of that decision, that 16 votes? Did they agree to it? I mean, these are things that we ask.
I tend to think that that might have been one of his conditions, one of Chief Escudero's conditions, or maybe his only condition on accepting the position of presiding officer, that the threshold must remain 16 votes. But even with his insistence on 16 votes, which seems to be favorable to the Cayetanos and their point of view, meron pa rin a resistance.
Yeah.
Is it really just because they think it will delay and also undermine cheese?
Yes.
We'll have the opening statement first.
I think we're getting ready also to hear from the three members of the House prosecution panel.
Nag-umpisa na ang impeachment trial.
Are we ready to
We
show
would
that?
like to express our commendation, of course, to the impeachment court for responding to the mandate of the Constitution. This is a win for the Filipino people because the accountability mechanism is happening, the Constitution is being followed. No? So natapos na po ngayon ang opening statement na magkabilang party, the prosecution and the defense. Also, na-address din po yung mga naiwang concerns during the pre-trial conference. And tomorrow, finally, we will be starting the presentation of evidence. I understand na na-pronounce na din ng impeachment court the sequence or order of presentation of articles submitted by the prosecution. And tomorrow, we will be starting the presentation of evidence for the first article to be presented, and of course, that is threat. Okay? So, nagpapasalamat tayo sa lahat ng mga sumuporta at sumusuporta sa buong prosecution team. Kasama na, of course, ang ating mga private prosecutors, ang ating mga kasama sa House of Representatives, including our spokespersons. Maraming salamat higit sa taong bayan na tumutok at patuloy na susubaybay. Because again, ito pong impeachment na ito, this is not for me. This is not for Kong Chen. Para po ito sa sambayanang Pilipino. Maraming salamat po.
Kong Chen, we will now entertain questions. Tina?
About the entry of plea, it was our position to place it on record na ang gusto talaga namin ay magkaroon ng formal entry of plea. We understand the position of the impeachment court that an entry of plea of not guilty is deemed from the filing of the answer of the respondent. We understand that. But it was our intention really to place it on record regardless of the decision of the impeachment court, to make it more organized, to make it more responsive to the mandate of the Constitution, and to make it consistent with the rules, including the past impeachment process. About the BIR box, we likewise understand the position of the impeachment court. Nevertheless, we filed a new request for issuance of subpoena, and that pertains to an expanded list of documents of the BIR, not only the ITR, which we believe are contained in the documents because that sealed BIR box was submitted to us in the HRIP because of our issuance of subpoena of income tax returns. About the threshold, tanggap po ng prosecution na talagang debatable ito, no? As to how we're going to interpret the threshold for conviction, which the Constitution says 2/3 of all the members of the Senate. Merong arguments for 16. Merong arguments na it should be based on the number of senators who are attending in the impeachment proceedings, no? Ang importante, maliwanag ang posisyon ng impeachment court, and for the prosecution, regardless of how we interpret the threshold, we are of course committed to present the evidence and conclude with a successful result of this impeachment trial. Hindi po kami talo. As a matter of fact, we are very much happy because impeachment is happening now. The impeachment trial is happening now. That is the most important part of what happened today. We were able to witness na nangyayari na kung ano ang mandato ng Constitution. And we claim that as a victory for the prosecution because the trial is happening already.
Dagdag ko lang po, masyadong maaga na salita ng sino nanalo o natalo. This is only the first day of the trial. And it's only the first day of the trial. At yung mga napag-usapan ay mga preliminary matters pa lang. Ang importante at ang panawagan natin sa lahat ay tingnan natin at suriin natin yung ebidensya na mailalakad sa mga darating pa na araw at linggo. Ang pag-uusga natin ng impeachment ay wala naman sa mga incidents na yon, hindi kung napatunayan ba yung mga paratang na nandyan sa articles of impeachment. At tulad na napakagandang sinabi ni Chair kanina sa kanyang opening statement, we are ready to prove the allegations of
Let's leave the press briefing of the prosecution. Let's have a look now at the press conference of Michael Poa, defense spokesperson.
Regarding the threshold, which later, earlier rather, na-set na 16 despite the absence of senators. What are your thoughts?
Well, for us, I guess, all I can say is the Constitution is clear, and I'll leave it at that.
Attorney, tomorrow magsisimula na yung presentation ng witnesses. Handa na po ba ang defense para sa first three witnesses ng prosecution?
Yes, in fact, handa kami today. Because all along, we thought na kahit today, masisimulan na, no? Kumbaga, ipepresenta na yung unang witness ng prosecution. So, handa na kami today. Yung magko-cross-examine, handa na rin, no? So, lahat yan, talagang nakahanda kami for presentation of evidence ng prosecution today. So, na-move siya to tomorrow, but it makes no difference, no? So, okay naman tayo for tomorrow.
Hanggang sa mga oras na ito, wala pa po kayo nakitang shocking sa mga ebidensya ng mga naging statement ng prosecution.
Wala naman po. Everything today from the prosecution and is expected. In fact, maybe perhaps everything from our end was also expected by the prosecution, di ba? Kasi it's really preliminaries. So, wala pa naman po tayo doon sa stage na yun. I think things will progress through as the days go by, no? As trial days go.
Sir, comment and reaction sa opening statement ni Congresswoman Cristo?
Well, she's entitled to have her own opening statement. So, wala naman tayong any violent reaction doon. She's well entitled. That's her opening statement. So, I think it would be unfair for us to comment or say anything against that. Okay. Thank you, everyone. We'll see you tomorrow. See you tomorrow. Thank you, Pa. Thank you.
That was the extremely brief press conference from the defense. I think you can see that Attorney Michael Poa was very confident, he didn't use the word that the prosecutors used, which was that they were happy. They seemed like a happy lawyer. Nothing to say, he said on the record, about the opening statement of the prosecution. He said they were ready to hear the first witnesses today. So this has been postponed to tomorrow. So other than that, it was really just a very brief touching base with the media. Looking at, we've taken a look at three different spokespersons giving press briefings. Yeah, your general impressions of the three, ano bang?
Well, they should not forget the statement of the presiding officer that they're being discouraged from actually discussing the merits of the case. I seem to remember Senator Escudero saying that. So I guess they'll be more contained now, as opposed to previous weeks when they were just throwing allegations against each other, really just also interrogating the evidence of the other side. But now I think they'll be more circumspect, and that's why I guess the very brief press conference of the defense lawyer shows you where they're headed. Yeah,
Presiding Officer Chief Escudero did enjoin all the counsel present to be mindful, to be circumspect outside of the impeachment court. So I think this is going to be a feature, of course, of this particular impeachment trial. There will be a lot of circumspect spin from the spokespersons, including the spokesperson of the impeachment court. So reporters will have to dig harder, go behind the scenes to try to see what's really happening. Let's go back to the opening statement of Congresswoman Luistro. She talked about, well, she ended her speech by appealing to future memory.
Yeah.
Sabi niya, and as she pointed out earlier already, na in the future they'll forget, who was involved here, how popular or whatever. The important thing is, was the Constitution followed? Anong reaction mo dun?
Okay, two things. I think it also has, again, going back to what the presiding officer said, because he also alluded to that to a certain extent when he cited that 5 officials have been impeached in history, right? Yeah. And he cited what happened after they were impeached. So Corona, of course, led to the ouster of the president, and then each may action except the vice president in the first instance.
In the first instance.
So what we're saying is, to a certain extent, people will remember what happened after an impeachable official is impeached, and whether or not they'll remember the noise, or they'll remember Alan Cayetano in his new look. Probably not, but maybe they will remember that at this point in time, the vice president was either acquitted or convicted. Ganun lang naman yun. So, but will it does it matter to the current generation, to the Gen Z? That's, the jury's out.
I'm struck by that appeal to memory because central to the opening statement of Attorney Sheila Season was also an appeal to memory. But in her case, it was, remember what they did to this vice president. Remember what, parang...
Remember na nanalo siya ng malaki.
Yes, so it's also memory is a function of vengeance. Parang ganon. Yes. You can't have a feeling of revenge, or if you don't remember what was happening before. So iba yung sa kanila, remember what was done to her, no? Yes. Yung sa kay Luistro naman is remember what they will do here. I was just struck by that appeal.
Battle of narrative. So this, you can already see the trajectory of how the events will play it out, how the prosecution will play it out. Transparency, accountability, this one is really like political persecution. Diba? This is
Yeah.
similar to how Corona's defense team also made its point before. Diba? This is the entire power of the bureaucracy and the legislature being used against a critic of the president.
I just wonder exactly what the defense will do. You did raise this earlier, so the presumption of innocence is there, so they want that to work for the vice president. So the prosecution has all the burden to prove her guilt. They don't have to do anything. Yes. But if you already are unable to reach 16 votes to convict, it makes you wonder exactly what kind of legal defense will they offer.
Yes. Parang, di ba? Parang they seem to say the subtext of that is, anyway, we have the numbers. I don't know, but we could be wrong, John. We could be wrong.
Yeah, that's what I'm worried about. I'm sure I share your concern also. Father Bernas, the late great constitutionalist, did say it's political justice. There's a judicial element involved, but there's also politics. And it's the way it's designed. And as Attorney John Molo reminded us earlier. So it's a numbers game. The game part makes it trivial, but it's all about numbers, right?
But but I think the numbers internally, there's that. There's also the numbers as far as the public is concerned.
Okay.
So, for example, if the prosecution is able to really show clear evidence that was probably shown before, but maybe in a more, I don't know, accessible manner this time. What if public opinion, a certain degree of public opinion shifts, right, against the vice president? Many of the pro-Duterte senators are re-electionists in 2028. So it's still, we still don't know what's going to happen. I think that's safe to say, because then you have the public, you have an elections coming. Sure, there's the Duterte base, but if you're running for re-election, that's a tight 3 million, 2 million votes. Diba?
Which reminds me, so there are 4 articles of impeachment approved by the House of Representatives. And Article 4 is grave threats, issued against the life of the President, the First Lady, and the Speaker of the House at the time. But according to the prosecution and approved by the impeachment court, this is the first article of impeachment that they will try to prove. Why do you think?
Because that's golpe de gulat, diba? This is visual.
Okay.
This is audio. You'll hear the vice president boasting that he can have the president killed. So it's really character. If you're building a narrative, you have to establish first, is she capable of the allegations hurled against her? Well, she is, because then we'll show that.
Okay.
We'll show character. We'll show tone. People will see her again in hall, diba?
Yeah.
So,
like what Luis said, ngayon lang may president na kaibigan ng hitman.
So, doon nila yon. And then, of course, the defense how will the defense deny that, diba? It's a video proof.
I think they're gonna plead freedom of expression.
Yes, they would. But it's not about freedom or about rights, diba? It's character. This is leadership. Diba?
Okay.
This is your vice president actually saying that he has contacts in the underworld.
But she did say that. May kilala ako.
Yeah.
And I already talked to him.
Yes.
Diba? Yes. But something you said, something clicked when I heard you say this. So yes, I thought, they'd start with Article 4 because it's, as you said, golpe de gulat. It's really shocking, and the evidence is there. It's her own video. But it's also, as you said, character describing, right? I mean, this will set the premise for the other alleged crimes.
Oo. Kasi if you're in court or in an impeachment court, diba, you're telling a story. So how will you best tell the story? This is not just a battle for evidence. This is storytelling. This is, need to be able to capture the narrative so that then it's a public theater.
It is political theater.
It is political.
It is political theater. On the other hand, they chose the ill-gotten wealth article of impeachment, and they're saving it for last.
I think, well, some would say it could be because it's weak, but to me, maybe it's the punchline, right? So you build a character, and then the punchline is that, see, she has amassed this wealth.
Yeah.
Pwedeng punchline yon, or pwedeng they're still gathering more. So there's that also.
And that's one of the bones of contention dug up earlier, no? Attorney Sison said that the Supreme Court decision last year disallowed any use of information going back before she became Vice President. And Congressman Chel Jokno said, actually, the court did not, in fact, say that. So it is possible to look into her records from all the way back to 2006. I don't remember exactly what the presiding officer resolved on this, but it seems to be like an open question.
Yes.
That they're going to be fighting this out.
And I guess Attorney Jokno really said it well, di ba? Bakit ang integrity ba? Sabihin, why do you limit it only to the term that she was Vice President when she continues allegedly to benefit from those that were amassed when she was mayor? I mean, that's their stand anyway.
Okay. The other articles of impeachment involve the misuse of the confidential funds, right? And it seems to me that their defense is inapprove the budget secretary.
I think that would be the strongest case of the defense. That article. I think yeah.
That's
I mean, of course, sure, there was this very few days that were spent, but ultimately they can say, well, this was approved.
But that's the article where the famous non-existent Mary Grace Piatos will figure in, right?
But again, narrative to eh. So they'll say, well, how come that the office of the president, in a way, technically, probably did not approve the execution or the deployment of it, but confidential funds is par for the course. Don't you have confidential funds? Pwede nilang laruin yun eh. So, in terms of documentation,
Yeah, that's right.
May documentation and execution, that's one thing. Policy is another.
So it's actually possible that what people took away from the Quadcom hearings about 2 years ago already, about Mary Grace Piatos, might not actually be the one to sink Sara, if the evidence is in fact there, but rather maybe the data about the ill-gotten wealth. Yung sabi mo nga, baka yun yung knockout punch. The last article of impeachment has to do with bribery.
Yes.
Giving large sums of money to DepEd people. First of all, that doesn't strike me as, just limited to her, right? I mean, this is how many politicians do it, right? But what do you think of that? Are the chances of that article of impeachment being proven?
Again, in terms narrative-wise, they can turn that around. The defense team can turn that around. Yeah. So it's really the Article 4 and then the unexplained.
And then
and of course the Piatos. But precisely we know that it's gonna be well. If the prosecution panel has something that they have not discussed in Quadcom in relation to the confidential funds, then I'm not sure about that, but it will further strengthen their case.
So the way I'm beginning to see the way they're structuring, the prosecution is structuring the articles of impeachment, their presentation of evidence, it's actually how we teach writing, right? The points of emphasis are at the start and at the end, and the weaker parts are in the middle. So you put them in the middle.
That's so true.
Right?
Yeah.
So
Hindi kaya journalist ang nag-craft nito.
Or, a fictionist or a creative writer.
Because you're telling, ultimately, it's how you'll tell the story. Yun lang yun.
Yeah. I see that the prosecution is still conducting their press conference. The prosecution actually named three
for tomorrow.
No, three representatives to serve as their spokesperson.
Yeah, that can't they just assign one?
I don't know. So I don't know if we will be able to rejoin that press conference in a bit. Also, our reporters are in the Senate. Jairo Boliedo, Dwight De Leon, Patrick Cruz. We will be hearing from them in a bit. Also, reporter Iya Gozum is also in the field. I think covering the protests outside the Senate. Let's talk about the protests a bit. I mean, was the Iglesia Ni Cristo surprise rally also connected to the impeachment?
Oh, definitely, definitely. It's
So
all
it
the
wasn't just
build-up.
Marcoleta?
Yeah, no, it wasn't just Marcoleta. Iglesia Ni Cristo is obviously sided with the Dutertes here, so it's still a build-up. I mean, to them, kasi, it's like you just model it, right? You, in a way, you weaken the prosecution's case, you weaken the impeachment case just by, chipping away.
Okay.
Right? Chipping away. So it's really just guerrilla tactics. No, it doesn't mean that halimbawa, was the Iglesia thinking that the ombudsman would back down? I don't think so. But it was a show of force anyway. So
Parang
just,
pitik.
Yeah, pitik lang. Hanggang,
I find it ironic that the Iglesia is taking the side of the political rival now of the president,
incumbent, yeah.
who is the son of the president who made the Iglesia what it is today, a political pivot for many political players. Very interesting that in the end they did have a huge rally. I think was it early last year, which was in support of both the president and the vice president, because the rupture wasn't complete yet. But now you're saying that they really have sided with the vice president?
Yes, and also for very practical reasons, John. It's 2 years down the road. So I guess Iglesia early enough wants to, is not already hedging its bets. It's made its bet.
Okay.
Yeah.
And it's also possible that they really are smarting from the plunder case filed against the very first Iglesia Ni Cristo senator. No?
Yeah.
We've always had high-profile, high-ranking Iglesia public officials, but they usually, like Serafin Cuevas, were given the justice secretaryship, right? I mean, that was their portfolio. They actually were very good lawyers. But now, for the first time, and maybe it appeals to them because you need more votes for the Senate than there are members of the Iglesia Ni Cristo. The fact that they have a senator representing, or coming from their faith, is a very big thing. So,
and not to forget, the Iglesia has been very influential in the judiciary. Not to forget.
That's right.
That.
Yes. Yeah.
So it's really like a big, diba? Like, wow, what is this? Our very own senator being now charged in the ombudsman, when in fact they have saved so many people in the past, precisely from punishment or because of the influence that they wielded. So,
do you expect more protests in the future?
Yeah. There'll be more protests. It's the end game for the president. It's a very polarized environment, both within the Senate. I mean, it's not just protests. Some disruptions, probably in the impeachment court. I mean, the Cayetano siblings already set the tone, right? So they'll take all the opportunities. So let's see. And it's also the majority is a fragile majority.
Yes.
So there's gonna be, everyone will be watching the moves of the presiding officer, but also of the new Senate president. So it's really, I don't wish to be in the place of the Senate president now, because then, of course, he also will have to show that he has leadership. And unfortunately for him, this is his chance to shine as a Senate leader, but he's not the presiding officer. So there's that.
Yeah, I was just talking to someone who thought that this impeachment trial might actually turn Win Gatchalian into a dark horse for 2028.
Yes, no. I've heard the same.
Yeah. But so you think now that he shares the rostrum with the presiding officer?
You know, ano naman, with Win, we have not seen Win the Senate president yet.
Yeah.
Right? So
True.
yeah, let's see. Win or Winry.
Or Winry. Incidentally, speaking of Risa, that was a good point that she responded to. The presiding officer ruled that there will in fact be no executive session.
Yes.
That the impeachment court will not countenance executive sessions because it all has to be out in the open. So which I think is a good reminder.
Yeah.
Our Rappler reporters will be joining us live from the Senate. Jairo Boliedo and Dwight De Leon, and also Patrick Cruz. They look none the worse for wear after more than 3 hours in the Senate hall. Jairo, Dwight, and Patrick. Hello. Jairo. Okay, Patrick, go ahead. Sorry. Go ahead, please.
So I covered the impeachment trial inside of the session hall. It's quite interesting. It's my first time covering an impeachment trial. Well, the first day of the impeachment trial, there's already a tension, particularly with the discussion of the senator judges pertaining particularly with the election of a presiding officer. If you can recall, prior to this, weeks before this, there was a motion adopted by the Senate allowing a senator other than the Senate president to sit as a presiding officer. So the session started with a motion to elect a presiding officer, and immediately the Cayetano siblings resisted that idea, saying na hindi ito proper at yung question nila yung legality of electing a presiding officer other than the Senate President. But ultimately, Senator Chis Escudero, as we already heard weeks before, na siya yung planong i-install as Senate President, as a presiding officer. But then, yun nga, eventually he was elected. But then, yung leading up to that, we saw tension. Interesting yung mga statements ng the Cayetano faction dito. So, kanina merong sinabi si Alan Peter Cayetano, which seems like patama doon kay Senate President Win Gatchalian, saying na since he is more than capable as a Senate President, why not siya yung mag-preside nitong impeachment trial. So, I think yung statement niya na yun comes also with the context na napatalsik si Alan Peter Cayetano bilang Senate President at yung pumalit sa kanya ay si Senator Win Gatchalian. And yung quite contentious din tong naging palitan ng Senate leadership dito sa Senado kasi nga lumipat yung mga kaalyado ni Alan Peter Cayetano dito sa Gatchalian block, namely si Senator Joel Villanueva and now si Senator Chis Escudero nga na naging ultimately presiding officer for this impeachment trial.
Yes. And Patrick, yun nga, ang daming unknown variables heading to today's trial. Actually, kanina parang tumawel ng higit 1 oras, sumabot ba ng 2 oras? Yung diskusyon doon pa lang sa election ng presiding officer. And actually, we're expecting na abutin tayo hanggang hating gabi today if ever sana nagkaroon na rin ng presentation of witnesses. But of course, that didn't happen because isasampina pa lang ng impeachment court or inapprove nila yung subpoena for the first two witnesses. They are the officials of the National Bureau of Investigation that will expound on the apparent threats made by Vice President Sara Duterte against President Ferdinand Marcos Jr., First Lady Liza Araneta Marcos, and former House Speaker Martin Romualdez. Alam mo, John, dito sa Senate, ang conversation, syempre, lalo pat unang araw ng trial, parang sino ba yung nakuha ng upper hand, sino ba yung, kumbaga parang nanalo on day one of the trial. And it seems like the prosecution has the burden to prove that they didn't necessarily lose the first day of the trial. Of course, it is a court of public opinion still after all. So, yun nga yung kailangang sagutin or sinagot na actually ng prosecution after the press conference. How do they address perceptions that they lost day one of the impeachment trial given the number of impeachment court rulings that were unfavorable to them. Una dyan, yung pag-set ng conviction threshold to 16. Although we were already getting feelers in the morning that the prosecution is no longer relying on a lower conviction threshold. Kanina nung umaga bago yung simula ng trial, pag tinatanong mo ang prosecution team, ang spokespersons, if they, what's their stand on the conviction threshold, they would say that, oh, we're ready regardless, ready kami to convince 16 senators. That's what the prosecution spokespersons were saying. This is a slight contrast from statements made by members of the prosecution weeks back, na they were floating the idea of lowering the conviction threshold dahil nga may mga non-functioning senators. So doon pa lang sa decision ni impeachment presiding officer Escudero, medyo dehado na yung prosecution. And then, nagkaroon pa ng another clash, face-off between impeachment trial lead prosecutor Jinky Luistro and Sheila Season of the defense team patungkol doon sa request ng prosecution for the immediate arraignment of Vice President Sara Duterte. But the defense team called it a waste of time. And the impeachment presiding officer, si Senator Escudero, denied the request of Jinky Luistro, saying that yung individual reading of articles will only be made before senator judges vote on the impeachment articles. And sabi rin ni Escudero, yung enter daw ng guilty or not guilty plea, it only takes place when the respondent fails to file an answer to the impeachment complaint. And the camp of Vice President Sara Duterte filed an answer, although answer ad Katelum to, ibig sabihin, filed with caution. So parang they still want to maintain their rights while answering the allegations of the prosecution. Ngayon, kanina, nung kausap natin ang prosecution sa press conference, they were saying that they just wanted to place it on record kung ano yung official plea ni VP Sara Duterte sa complaint at para daw mas maging organized ang proceedings. Tapos yung pangatlong issue, yung tungkol nga sa BIR box, because for some time now, the prosecution is insisting that the BIR box containing presumably the tax records of Vice President Sara Duterte should be opened here at the impeachment court. Kahit nung pre-trial proceedings, yan yung sinasabi nila. But that didn't happen, and worse, Escudero ordered the return of the BIR box to the BIR. Escudero reason na wala namang daw lawful order na in-issue ang impeachment court for the box to be turned over to the Senate at this point. Aminado si Congresswoman Jinky that she was surprised by this decision by the impeachment court. But she also said na baka naman nag-iingat lang ang Senate impeachment court. Again, this stems from concerns that opening the box would violate the National Internal Revenue Code. Kahit nga sa House ay hindi binuksan ng mambabatas yung box during its clarificatory hearing dahil nga nag-iingat pa rin. So ganun yung mga rulings na seemingly unfavorable to the prosecution. But Jinky Luistro is saying that they feel victorious on day one. Of course, they're going to say that. But there's a lot of uncertainty heading to day 2, day 3 kung ano yung ipoproject ng prosecution na strength. Again, maalala natin a few weeks back, ang prosecution, they faced these rumors, especially Congresswoman Jinky Luistro, that kinain siya ng buhay ng defense, specifically Attorney Sheila Sison. So ngayon yung unang pagkakataon na nakita natin live yung exchange. And Jairo, you covered the defense team press con. Sila ba? Did they think that they won or they got the upper hand on the first day of the trial?
Alam mo, Dwight, the defense strategy kasi is to be very congenial. That is very, on brand with the brand of the Duterte politics na caring sila, na sila yung naaapi, na sila yung laging underdog. And if you hear Attorney Powa, Michael Powa, speaking, laging ang kanyang argument or laging kanyang sinasabi ay sila ay laging rumerespeto sa mga proseso. So when we ask him after the first day of the trial during the press conference if sa tingin ba nila nanalo sila given the 3 motions nga na hindi na basically sila yung pinaboran nun at this point, sabi niya ay they don't want to assume and they don't want to think that way. They're just focused on the trial itself, and that's easy to say because they're the defense after all. They don't have the burden of proof. All they need to do is to cast doubt on the allegations, cast doubt on the evidence being presented by the prosecution. They have the easier job here, so to speak, because the burden of proof, again, yung trabaho po na patunayan itong mga alegasyon na ito ay wala kay VP Sara, kundi nasa prosecutors po ng House of Representatives. And going back to giving you the point of view, John Glenda, ng defense today, hindi dumating si Vice President Sara Duterte as expected. She never appeared during the mini trial of the House Committee on Justice, or as the House calls it, a clarificatory hearing for the articles of the impeachment, the allegations. Di siya umattend doon sa ilang araw na hearing na yon. And then nung na-impeach siya, umakyat dito sa Senado ang articles of impeachment para sa pre-trial conference, hindi rin siya nagpakita. We were asking repeatedly si Attorney Powa if the Vice President would appear one of these days. Sabi niya, it's really uncertain at ang advice nila ay dadating lang siya kung kinakailangan. And today nga, hindi siya nagpakita. But let me clarify it. Under the rights ng respondent in impeachment proceedings and even in other cases, hindi naman talaga sila required to appear all the time. And in this case, ito ay sui generis, itong impeachment proceedings. So, ang kanyang appearance ay through her lawyers. At yan nga yung pinalawanag kanina ni Attorney Sison na kaya technically hindi na nga kailangan ng arraignment dahil hindi naman na-waive yung right niya because sumagot naman nga siya, although ad catelam nga, may caution, sumagot siya sa allegations, and cooperative, nagpapakita yung kanyang mga abogado. Ngayon, doon sa speech kanina ni Attorney Sheila Sison, nagtagal yon ng 16 minutes. Basically, I can sum it up by saying that she poked holes on the allegations of the House of Representatives individually. Pero ang pinaka-highlight doon ay yung sinabi niya na questions on the confidential funds. Nakita naman natin sa pre-trial brief that they are trying to put on the witness stand itong si dating DBM Secretary Amena Pangandaman at dating ES Executive Secretary Lucas Bersamin in relation to the confidential funds issue, which is the first articles of impeachment. Now, ang pinupunto ni kanina ni Attorney Sison ay actually si Marcos ang nag-approve ng confidential funds to begin with. But I asked Attorney Powa kanina, yes, it was the Malacanang which approved the confidential funds, but it was actually the Office of the Vice President and the DepEd which disbursed or used those funds na questionable yung disbursement ayon sa House of Representatives. Ang sabi ni Attorney Powa ay iyan ay merit, so hindi muna sila magko-comment dyan at nandyan ang trial to answer those questions. Apart from that, isa sa rin sa mga striking points, Dwight, Patrick, kanina rin, ni Attorney Sison ay yung ginamit yung term na we as a nation never forget. That is an indirect allusion to the Marcos family because the we never forget phrase is used as against or as a protest against the atrocities of the martial law under the regime of Ferdinand E. Marcos, the father of the current president. At isa rin sa mga highlight ng speech ni Attorney Sison ay yung paulit-ulit niyang paggamit ng Supreme Court 2025 ruling na nakitang unconstitutional ang articles of impeachment ng House of Representatives in 2025. In fact, sinabi niya pa nga doon na impeachment is not purely political, it's also a legal mechanism it's an allusion also, it's an attack actually to the to the House of Representatives, saying that you should base your allegations, your rules, your proceedings on the available rules of court or the rule of law. Ngayon, kanina ay tinanong din natin si Attorney Powa on the threshold. Sabi niya ay nirerespeto naman nila lagi daw yung desisyon ng Senado. Alam niyo, ito kasing defense, Dwight, Patrick, Glenda, John, very careful sila all the time. Aggressive sila during the closed doors, katulad kanina aggressive sila during on the floor. Pero during media interviews, careful sila and calculated yung mga sagot nila. So, hindi talaga sila masyadong sumasagot. Lagi na tinatanong, lagi nilang sinasagot sa amin, either attorney, client privilege, or sasabihin nila sub judice, which they cannot really, disclose merits. But they can always actually discuss things that are not necessarily discussion of merits, but they choose not to. And lastly, sabi nila, ayun nga, they don't want to think that they got the upper hand during the first trial, but ready sila all the time. Sabi nga nila kanina, they were kind of expecting din daw na matutuloy ang presentation of evidence or testimonial evidence ng prosecution kanina with the witnesses from the House of Representatives and the National Bureau of Investigation, pero hindi daw natuloy. Pero ready naman daw sila anytime. So far, hindi pa rin daw nakakausap ni Attorney Powa si Vice President Sara Duterte regarding today's developments, pero mag-uusap daw sila later on to give her updates. John, Glenda.
Thank you, Jairo, Dwight, Patrick. So much to respond to. I have many questions. First, for Patrick, in the last few days, there seemed to be the impression coming out of the Senate that the backlash against the possibility that Chis Escudero would be presiding officer would be addressed because Win Gatchalian, the new Senate President, would be the presiding officer. So even the pre-trial order signed by Chis as presiding, by Win Gatchalian as presiding officer. Was this a deliberate attempt to sort of deceive the public, protect Chis Escudero from further criticism?
I think it's not necessarily that. I think it's also a matter of the timeline. Because if you look back, nagkaroon ng medyo tight din yung naging schedule ng Senado dahil nga dun sa series of events dito sa Senado, yung kaguluhan, yung barilan, yung arestuhan, and today nga, Senator Marcoleta inaresto rin. So yeah, there's that. Also, I think the Senate majority or the Gatchalian bloc initially has a discussion or a debate kung sino ba talaga yung i-elect nila as presiding officer. So there were, according to Senator Lacson in an interview, he said na they are choosing between Senator Kiko Pangilinan, who is also a lawyer, and Senator Chis Escudero, who is also a lawyer. So according to him, meron daw parang division din among them kung sino ba talaga yung pipiliin. But then ultimately, si Senator Chis Escudero nga yung inelect nila as presiding officer despite yung public opposition nga given his yung background or on how he handled yung trial before.
Thank you. Dwight, what did the other House prosecutors think about the opening statement of Congresswoman Jinky Luistro? Any feedback from them?
Well, of course, the prosecution team is in support of the opening statement of Congresswoman Jinky Luistro. Actually, si Congresswoman Jinky, when you listen to her speak, it's quite long, pero she knows her sound bites. And the speech itself is a reminder to the Filipino public why this impeachment trial is something that should be important to them, because this is their money. This is something that a teacher, an ordinary Filipino should monitor on a daily basis. Alam mo kanina, after kasi nung trial, ang nakausap lang natin ay si Congressman Chel at saka si former Congressman Ace, the impeachment advisor, katabi niya si Congresswoman Jinky. And they were saying na, yun nga, that they feel victorious after day one of the trial. Si Congressman Chel was also saying na parang it's too early to say naman na may nanalo o may natalo dahil nagsisimula pa lamang ang trial. So, ayun, it's kind of too early to tell, but we'll see in the coming days how the prosecution will project itself in the court. Actually, nakita lang naman talaga nating nagsalita today si Congresswoman Jinky tsaka si Congressman Chel, but it remains to be seen how prepared other public prosecutors are and how much assistance yung mapoprovide noong mga private prosecutors na tinap nila, who themselves are really, really seasoned litigators as well.
Glenda has a question for Dwight also.
Hi, Dwight. Yes. Anyway, you've covered the Quadcom and you've been in touch with the prosecutors. You think they will change tactics in a way now that they're going back to the drawing boards and they somehow they have the 16 votes, etc. Do you think there's gonna be a shift in the way they'll present, or there's more burden on their part to strengthen their case?
Well, I feel like after this they will have to regroup, especially dahil nga may tatlong rulings on motions, tapos hindi yon favorable sa prosecution. Although I find it difficult to imagine na hindi nila in-expect some of the rulings today. For example, yung conviction threshold. They must have seen it coming that the impeachment court won't lower the conviction threshold. I was in talks with some House insiders a week ago and pinagsabihan, narinig ko lang na pinagsabihan niya ang prosecution na maybe let's not focus on that. Let us not make that a talking point because it might signal some level of weakness from the prosecution kung sa simula pa lang ng trial we're already discussing if we could lower the conviction threshold. Also, I find it difficult to imagine that the impeachment, that the prosecutors didn't consider how Escudero will play a role in this trial, given that doong nakaraang taon nga si Escudero made decisions that seemed very favorable to the Sara Duterte camp. Although, Glenda, I would like to posit siguro another perspective on Escudero, that this is an opportunity to redeem himself to the public eye. Kasi meron ding perception na maybe he'll be the same Escudero as last year, but this is an Escudero that is now facing cases of corruption, and this could be an opportunity for him to prove himself that he is a proper presiding officer. May mga discussions tayo with lawyers na si Corona, during the Corona trial, Enrile ran the impeachment court like a tight ship. And dito sa unang araw ng impeachment court, it seemed like Escudero made decisions na quick and he allowed everyone to speak, but at the same time, he knew the direction of the trial on the first day, hindi niya pinatagal. And at least tomorrow, alam natin na there's a possibility that the trial witnesses of the prosecution will already face the impeachment court.
Thank you. In a bit, we'll be going back to the press conference of the prosecution. But I do have a question for Jairo first. No? Jairo, you said, and I can see for myself, the defense counsel, they're congenial when talking to the media and so on. Pero there were 2 or 3 instances during the trial na may skirmish, I guess should we be expecting more of that in the future?
I think yes, especially that we are talking about experienced litigators, whether we like it or not. The House prosecution itself acknowledges the fact that they need the expertise of private prosecutors because they lack expertise on the area of litigation. As you know, John, Glenda, law is a very vast practice itself. Hindi porket lawyer ka, you're an expert on the other aspects of law, including litigation. Litigation is, an act on its own. It's a field of its own. It takes experience, facing the court, arguing before the court or presiding judge, and talking to other parties. That is something that Sheila Sison and her team of lawyers from Fortuna Narvaza Salazar Law Office are very experienced with, given the big cases that they've handled. Let us not forget the Fortune Salazar and Narvaza Salazar. It's the same law firm that handled the Ampatuan case originally before they withdrew, and they're also the law firm that is behind big cases such as the Mighty Corporation case against the Bureau of Internal Revenue. Tax cases man ito, but they are very, very experienced with litigation, and that's what we are going to expect in the past days, given the fact that experience sila, they know what they're doing, and they're really familiar. Kita natin kanina si Attorney Sison, iniisa-isa niya yung rules of impeachment proceedings ng Senate. She did her assignment, in other words.
Maybe one last question for the three gentlemen. Do we already know who the witnesses are or will be for tomorrow?
Yes, I think Dwight already wrote about it, and it was already announced during the trial earlier. Originally, the House of Representatives requested to present two director and agent from the National Bureau of Investigation, Kalilong and Lotok. Sila yung nag-authenticate ng video ni Vice President Sara Duterte nung kanyang breakdown threatening the president and his family, and then the other one as yung the House official na present during sa House of Representatives nung nilak ni Vice President Sara Duterte yung sarili niya at nag-hold nga ng Zoom press conference kung saan nga ginawa niya yung alleged threats laban dito kay President Marcos at sa family niya.
At saka yung isang agent, siya yung nag-confirm during the clarification hearings that Sara Duterte indeed hired an assassin
yes,
to kill the president. Although syempre yun yung malalaman natin kung na-identify ba ng NBI yung agent na yun or willing na ba silang i-identify yung assassin na yun during the trial proceedings tomorrow or on Wednesday.
Dwight De Leon, Jairo Boliedo, Patrick Cruz, thank you very much. It's been a very interesting first day. Maybe some last takeaways?
I think I agree with Dwight that it's, and with the three of them, it's early innings. Even the way the presiding officer presided over the trial, even if, he seemed to have favored the defense more in this case, no, it's early innings. It's a political theater. A lot of the actions in that impeachment court will also depend on how the public will see this.
And the threshold decision, the threshold
decision is, again,
pivotal.
It's pivotal, and that's why the burden really is for the prosecution to strengthen their narrative, to make it compelling, because the judges will flip if the public will be so outraged by what will be presented. So there's still, it's early innings.
Yeah, I know. I mean, they asked for a total of, what is it, 92 trial dates. I don't know if they'll hold all 92, but this is a long process. We just got started. Thank you.
Thank you, John.
Well, that was day one of the impeachment trial of Vice President Sara Duterte. We would like to thank Rappler Executive Editor Glenda Gloria, Constitutional Law Expert Attorney John Molo, and of course our reporters in the Senate, Jairo Boliedo, Dwight De Leon, and Patrick Cruz. We will see you again tomorrow for Rappler's special coverage at 1:30 p.m. I'm John Nery. Good night.